Go. All right, good morning, everyone. My name is Charles Allen. I'm the Ward 6 council member and chair of the council's Committee on the Judiciary and Public Safety. Today is Thursday, December 16th, 2021. We're convening this morning over the Zoom virtual platform. The time is now 9:40 a.m. and I'm calling to order this public hearing of the committee. We don't have any of my colleagues have joined me yet, but as they do, I'll make sure I recognize them and give them a moment for an opening statement. Today, the committee will be considering Bill 24-0416, the Revised Criminal Code Act of 2021, which was introduced by Chairman Mendelson at the request of the Criminal Code Reform Commission, which is an independent district agency, on October 1st of this year. The bill would comprehensively overhaul the district's criminal code to improve its clarity, completeness, consistency, and proportionality, transforming our outdated code to one that's more accessible to the general public and reflects our district values. This is the committee's third public hearing on the measure to date, and today we'll be hearing from our government witnesses and the other members of the commission's advisory group. Members of the public were invited to testify at 2 day-long hearings earlier this fall, and we heard many hours of testimony from both individuals impacted by the code and organizations. They highlighted parts of the bill that they agreed with, parts that they didn't, and I know that I was left with a much better understanding of both the scope of what's before us and the diversity of perspectives on its proposals, but in general, strong support for the package as a whole. For anyone watching today who hasn't caught our prior hearings, for context, the district's criminal code was first enacted by Congress back in 1901, well before the Home Rule. 70 years later, the council was granted the authority to enact its own criminal laws. However, we've never comprehensively modernized our criminal code, and as a result, it's been ranked as actually one of the worst in the United States. About 15 years ago, the council initiated a criminal code reform project through what was at the time the DC Sentencing and Criminal Code Revision Commission. When the CCRC began operation as an independent agency on October 1st, 2016, it assumed the responsibility of developing comprehensive recommendations for criminal code reform. The CCRC's enabling statute also created an advisory group to support the agency throughout the drafting process. And those are the witnesses before us today. That advisory group was composed of representatives from the Office of the Attorney General, the U.S. Attorney's Office for the District of Columbia, the Public Defender Service, and 2 subject matter experts, Professors Paul Butler and Don Brayman. In addition, the Deputy Mayor for Public Safety and Justice and this committee's chairperson, currently myself, have been non-voting members. The core advisory group members have spent many hundreds, if not thousands, of hours poring over every single offense, debating the principles underlying our code, wrestling with many fact patterns to try to get this right. These meetings were open to the public and produced thousands of pages of support for each aspect of the package. And in the end, the commission effectively put forward what is a model law for the district that adopts many of the best practices and recommendations from other jurisdictions, and the model penal code. It's been a massive undertaking. And since all the advisory group members are here before us today, I want to thank them truly for their service to the district and that they should be very proud of what they've accomplished thus far. In March, the agency's final recommendations were approved unanimously by the advisory group and submitted to the council for our consideration. And that's the stage of the process where we find ourselves today. So now let's briefly go over some logistics for this morning's hearing. Again, today we're going to be hearing exclusively from members of the CCRC's advisory group, but members of the public can still submit written testimony to Judiciary at dccouncil.us until December 24th. Our witnesses will be joining us today on Zoom as panelists. If at any time you need any assistance, you can use the chat function to reach out to committee staff. The committee will set a timer for 10 minutes per witness as a guidepost. We are going to, as we do with our government witnesses, what I'm going to do is have everybody take an oath for their testimony, and then we will turn and begin with testimony. So if everyone would, please raise your right hand. Do you swear or affirm on the penalty of perjury the testimony you're about to provide the Committee on Judiciary and Public Safety is the truth, the whole truth, and nothing but the truth?
Yes.
Excellent. Thank you all very much. Let's see here. I actually closed my document. I apologize of who is going to go first. Mr. Schmeckel, did I have you lined up to go first?
I believe so.
I believe so. Okay. All right. So Mr. Schmeckel, I'm going to turn to you while I reopen my document. And by then we'll be ready for the second person. So Mr. Schmeckel, good morning to you. Let me turn to you.
Good morning. Chairman Allen, thank you and your staff for holding this third hearing on the Revised Criminal Code Act of 2021, the RCCA, submitted by the DC Criminal Code Reform Commission, the CCRC. During the first 2 days of hearings, we heard from subject matter experts, multiple victims groups, people with lived experience in the incarceration system, and other public witnesses who unanimously, as I heard it, gave their general support for the bill. A number of witnesses said more should be done. to reduce penalties or decriminalize drug possession. And there were a few concerns raised about the drafting of specific provisions and ensuring that available resources were available to successfully implement the reforms. The broad consensus that the bill should be passed, however, is a real testament to the need for comprehensive modernization and the careful process used to assemble this bill. As the committee looks forward to finalizing the bill next summer or fall, as I've heard before, the CCRC stands ready to assist. I also want to thank the CCRC's former advisory group members testifying today for their years of work on the bill's language. Realizing the need to go beyond what piecemeal legislative efforts could accomplish in the past, the district has invested considerable time and resources to develop a plan for comprehensive reform of the criminal code. As you mentioned, legislation 2006 first mandated the development of code reform legislation to the then Sentencing Commission. And for nearly a decade, work went on with government partners there, but did not yield results. Undeterred, the council then created the CCRC about 5 years ago and directed it to provide recommendations that improve clarity, consistency, completeness, organization, and proportionality of criminal statutes. The CCRC was directed to examine model codes and best practices, as well as relevant court statistics. But I think arguably the most critical aspect of the process set out in the agency's statute was the designation of the advisory group. These are folks with deep connections to the local criminal justice community, and they were available to provide comments on all the agency's drafts. 7 members in total, representatives of the district's attorney general, U.S. attorney for the district, DC Public Defender Service, Deputy Mayor for Public Safety, and this committee, as well as Professors Brayman and Butler. The advisory group held years of monthly meetings with staff, all of which were open to the public. The advisory group members themselves gave hundreds of pages of written comments on drafts, which amounted to materials in the thousands of pages. Staff addressed every comment that was received from the advisory group, those who submitted comments in writing. And in the end, as you mentioned, all 5 voting members of the advisory group approved submission of the CCRC's recommendations to the mayor and the council on March 31st. It really has been a multi-year, transparent, research-driven process working with this advisory group to develop the RCCA before you now. And I'm very grateful for their work. Now, on the first day of hearings, I spoke more to the problems that exist in the current criminal code, the need for reform, and the main features of the RCCA bill. Today, I want to focus more on the bill's comprehensive changes to penalties. And I'll briefly address first how the topmost penalties were set, second, how other penalties were ordered and set, third, why mandatory minimums were rejected, fourth, why proportionality is really about discerning all the applicable penalties for behavior and not looking at just one crime, and fifth, why there needs to be a judicial review of long-term sentences to see if they still serve public safety and justice. I also want to point out some of the current research on how long imprisonment sentences affect public safety and data on some of the extreme racial disparity in incarceration in the district. First, how the topmost penalties were set. So no specific numbers for criminal code's imprisonment penalties are widely accepted or expert recommended because there are just so many different competing values at stake. However, there is some agreement among experts about the topmost number. The Model Penal Code's recently revised sentencing provisions issued by the American Law Institute provides the most authoritative recommendations on the matter. And they recommend that the most severe penalty in a non-death penalty jurisdiction like the district should be life with the possibility of release. Below that, the Model Penal Code says that the way specific penalties are assigned are fundamental policy questions and questions that can actually change over time. The RCCA follows the MPC recommendation by setting the penalty for the most severe crime, first-degree murder, at 40 or 45 years, depending on aggravating factors. And that 40 or 45-year top number is based on the under 69-year average life expectancy for those who are typically convicted of those top murder crimes in the district. They're realistic approximations of what life with the possibility of release might mean. Second, how are the other penalties ordered and set? So while there's no consensus on specific punishment numbers, common sense logic and well-established norms do provide a relative order of penalties for offenses of the same type. There's broad agreement that along the same spectrum, a mere threat of causing bodily injury or a failed attempt to do so is not as serious as actually causing such an injury. An assault that causes a bodily injury like a simple bruise is not as bad as a deep cut requiring help from a medical professional. An injury that puts a person at risk of death is worse still, and killing someone is the greatest bodily injury. So we have a spectrum here, and while they may differ as to the exact penalties associated with the harms, virtually all criminal codes nationally differentiate bodily injury harms and their authorized penalties, from murder at the top to the most minor unwanted forms of touching at the bottom. The RCCA does this same thing. Below the most severe penalty for murder at 40 or 45 years, the bill provides lower penalties that differentiate lesser types of bodily injuries in similar ways and actually with similar penalties as the current DC code. And to get insight on offenses other than assault type crimes, I want to highlight that the CCRC conducted a large 400-person demographically weighted survey of district voters. Residents were presented with short scenarios, such as a person stealing $5,000, and asked how that conduct as a whole compared to various assault type harms. In this way, the agency was able to create a map of the public's view of the relative severity of a multitude of behaviors compared to these assault type harms of inflicting bodily injuries. I don't want to overemphasize the importance of the survey findings because a lot of other statistics were examined. DC court sentencing data, national court data, other sources too. But it's notable that the common sense rankings by today's district voters often differed quite sharply from those that are now authorized under the DC code. Third, why mandatory minimums were rejected. So as discussed with the group, a criminal code's authorized penalties must account for both the worst and the least serious ways that prohibited conduct can be committed. When people think of a crime, they may envision a specific scenario, but in setting a code's statutorily authorized punishments, the penalty must fit the full range of ways the covered conduct can occur. Unlike sentencing guidelines that are built around typical facts, a wider range of sentences, both low and high, must be authorized in statutes to account for rare scenarios. Mandatory minimums that do not fit the least harmful forms of an offense are not justifiable. And following the recommendations of the Judicial Conference of the United States, the Model Penal Code, the American Bar Association, statements by U.S. Attorney General Merrick Garland, for all these and other reasons that are in the literature, the RCCA ends mandatory minimums. Conversely, statutory maximums that don't account for the most severe form of an offense also are not justifiable. But that leads me to my fourth point, why proportionality is about all the applicable penalties in a code, not just one crime. All of a criminal code's chargeable crimes really have to be considered when determining whether the penalties are sufficient for an offender's conduct. When the law authorizes multiple punishments through variously named crimes for what in reality was a single instance of conduct, well, in that case, prosecutors have discretion to charge all the applicable crimes. Judges then generally have the discretion to set sentences for those crimes to run consecutive to one another so that the imprisonment sentences for those multiple convictions add up, stacking up one on top of the other. The upshot is that looking at the penalty for just one of the crimes that can be charged based on an offender's behavior often is misleading as to the liability that the law actually imposes. What matters is whether the total amount of imprisonment authorized under the criminal code as a whole with all of its overlapping ways of criminalizing behavior and various enhancements, whether that is sufficient, that whole set of imprisonment penalties. The RCCA drafts offenses to minimize the possibility of having multiple punishments from what is really one instance of behavior. And when overlapping charges are necessary, it adjusts penalties to try to account for that overlap, to create an overall proportionate response. Fifth, why there needs to be a judicial review of long-term sentences. Even the best designed sentencing laws implemented by the most skillful judges can still get it wrong. District judges are not infallible. They can't see into the future. They must work with imperfect information about potential threats to public safety, the likelihood of rehabilitation, and try to track evolving public norms about the seriousness of certain criminal behavior. Parole laws and regulations in most other jurisdictions provide earlier opportunities for release for those serving long-term sentences. Unfortunately, in the district, federal law has eliminated the district's parole board, limited reductions in incarceration for good behavior to a maximum of 15%, and deprived the mayor of commutation and exoneration powers ordinarily available to the head of the executive branch. Consistent with the Model Penal Code's sentencing recommendations, the revised statutes in the RCCA provide judges with an opportunity to reassess the continued justification for incarceration of an individual after at least 15 years of time served. This helps ensure the ongoing proportionality of punishments in the district's criminal justice system by permitting a sentence modification when the court finds there is no further threat to public safety. This change mitigates some of the harm caused by federal limitations on parole in the district. In closing, I want to say just a few things about public safety and race, which are deeply entwined with what decisions the council makes about changing imprisonment penalties. First, any level of violent crime is too much, and the current increase in homicide is deeply troubling. It's also important, though, to recognize overall levels of violent crime in the district have been steady the last few years, according to MPD data. Those levels are actually near the lowest in decades per FBI data, and are about a third of the peak violence that the district experienced in the 90s. There's no reason to believe that the moderate penalty reductions in the RCCA as compared to current Superior Court practice will lead to an increase in crime. As the National Research Council summarized, the evidence in the research is clear that, quote, long sentences have little marginal effect on crime reduction through either deterrence or incapacitation, end quote. Other states have done this. Other states have successfully lowered their incarceration rates through sentencing changes and seen decreases in crime. And I think the district can do that too. Second, the council's decision whether to maintain the status quo, to follow the penalty changes in the RCCA, or to take another path on sentencing is primarily about the futures of young Black men in the district. In the 55,806 Superior Court cases with race and gender data that was available and we analyzed for this past decade, we found that 77% of the defendants were Black males, even though they comprise only 20% of the population. Objectively, the district has one of the highest incarceration rates in the country, or if you extrapolate it out to the world. Given those facts, and absent any clear evidence that longer sentences are necessary for public safety, reducing authorized penalties is compelling as a matter of racial justice. The bill, and final words here, the bill doesn't fix all the problems or inequities in the current criminal code. The bill remains mostly based on the current system's choices about what is worthy of criminalization, and it still provides high incarceration penalties. It is both a major step forward and also moderate. And I hope the council will pass the RCCA, but will also not cease to look for other ways to improve the district's criminal laws. The agency, the CCRC, is certainly here to assist with that. Thank you.
Thank you very much, Director Schmeckel. Next, we're going to turn to Deputy Mayor for Public Safety and Justice, Chris Geldart. Deputy Mayor Geldart, let me turn to you now.
Good morning, Chairperson Allen. I don't think we have any other members on, but if they are on, good morning to you all as well, staff and committee of the Judiciary and Public Safety. I'm Chris Geldart, the Deputy Mayor for Public Safety and Justice. I'm here today to provide the executive testimony on Bill 24-0416, the Revised Criminal Code Amendment Act of 2021, or as we have been calling it here, the RCCA. I want to thank Director Schmeckel and his staff for their thoughtful work over the last 4.5 years to develop its recommendations. We appreciate the need for a comprehensive update to our criminal code, which has not undergone such an update since 1901, has been stated. However, I want to raise two significant executive concerns that we believe should be addressed prior to the implementation of the breadth of systematic changes proposed in the RCCA. The first is the need for opportunity for a meaningful participation by residents. The mayor has stated that the most persistent and pressing issue that we face as a government is ensuring the safety of our residents we serve. Given the significant impact of our decisions on our residents, it is important that we center them and their safety in every action we take, and must be guided by our responsibility to advance public safety. And the best way for us to ensure that our residents' safety is primary consideration is by allowing them to have a meaningful opportunity to make their voices heard. Legislation such as the RCCA, or RCA, that will greatly impact the community needs to be considered in a manner that ensures that nothing happens to the community without the community. To do this, we believe that conversations that take place in the community, educating the residents on the proposed changes and their impact, should be a part of this process. It is the executive's priority to ensure that the residents feel safe. Prior to passing massive criminal justice reforms that will have both significant intended and unintended impacts on resident safety, it is imperative to educate and communicate with residents, to hear their questions and concerns, and to ensure whatever balance is selected between criminal sentencing of offenders and neighborhood safety is reflective of the residents of the District of Columbia. Currently, the majority of residents are not aware of the changes proposed by the RCCA and its impact on their community. We respect the efforts that have been made by the CCRC to allow for transparency and the public participation. That process has resulted in approximately 500 residents being heard. We also recognize the council has engaged in the public by conducting 3 hearings, resulting in testimony by Director Schmeckel, 25 representatives from selected organizations in the district, and 25 members of the public, including 1 ANC commissioner. We recognize that all 705,000 district residents that will be affected by the bill's changes and its impacts on our agency's ability to preserve public safety in their communities will not be able to participate. Nonetheless, we still believe a process as thoughtful as the one that resulted in the creation of the bill should allow for as much thoughtful consideration and meaningful participation as possible from more of the residents who will be impacted. To better reach residents impacted by the legislation, the committee could use platforms like neighborhood ANC meetings, council roundtables in each of the wards, and community office hours to educate the residents about some of the major reforms contained within the RCCA. By proactively engaging the community about the reforms, the council will ensure the balance between public safety and proportionality accurately reflects the thoughts, feelings, needs of the district's diverse communities. Secondly, the need for the opportunity for meaningful participation by implementing entities. While the executive is generally supportive of the RCCA, we are concerned with the speed the council appears to be moving on the RCCA. Given the thoughtful process the CCRC undertook to arrive at the proposed changes, it seems wise to employ an equally thoughtful process in evaluating the bill's impact and allowing for a collaborative process for creating an implementation strategy that will not upend the fragile public safety and justice ecosystem. As I previously stated, the safety of our residents is our North Star, and we recognize that our residents do not currently feel safe. We are working very hard every day across our ecosystem to ensure that every part functions in a way that will increase safety across our city. And a major reform to the criminal code, no matter how necessary, is sure to impact that functioning. Our public safety and justice ecosystem is unique in the wide range of local and federal individuals and entities that participate in it. In order to ensure that we act in a manner that advances the administration of justice while also advancing public safety, it is imperative to ensure that an implementation plan has ample time for all those involved in the system to be appropriately educated and trained on the changes. It will also require our public safety and justice cluster agencies to ramp up operations to ensure that happens. Currently, my office and the public safety and justice cluster agencies are still in the process of trying to assess the impact of the proposed legislation on operations, service delivery to the residents, the time needed to train employees on the RCCA, and the practical realities of implementing such a comprehensive systematic change. However, there are a few notable concerns raised thus far. The RCCA changes the elements required to establish probable cause for all offenses, which will require, at minimum, 80 hours or more of retraining of all MPD members and an investment to train individuals with the authority to take police reports or make arrests in the district. It redefines elements of rioting, now requiring officers to find probable cause to commit another crime before making an arrest, as well as felony murder, now eliminating accomplice liability, thus requiring the government to prove precisely who fired the fatal shot. Replaces the word victim with complainant, which could have unintended consequences for victims' rights and compensation. I recommend the council speaks directly with Director Garcia from the Office of Victim Services and Justice Grants, who has also identified several provisions for further review, including the failure to adopt the model stalking code and issues surrounding consent. It also creates a new kind of probation called deferred disposition for all misdemeanors. More individuals on probation may require additional supervision from CSOSA. The committee must ensure CSOSA has the staff, resources, and capability to implement this successfully to limit inconsistency and frustration. It also potentially strains our already stretched justice system by expanding jury demandability and access to second look judicial review. This vast expansion of trials and hearings would strain both prosecutorial and court resources. The executive is concerned that the added workload on the courts will result in delayed justice for victims, as victims will need to wait longer for cases to be resolved at trial. To give an idea of the potential magnitude of the shift, in 2019, only 11 out of over 600 misdemeanor trials were held before juries. Where under the RCCA, approximately 300 to 400 of those trials would be eligible for juries. While not exhaustive, the above concerns demonstrate the types of issues that should be addressed and resolved in advance of implementation. The more time allowed for thoughtfulness, collaboration, and communication amongst impacted stakeholders, the better the impact on our public safety and justice ecosystem, and more importantly, on our residents and their safety. This is not the first time the council has undertaken major reforms, so there are models for us to follow. One example is the zoning regulations rewrite of 2016, the ZRR. ZRR began in 2007 with the Zoning Commission holding 2 roundtables and concluded on January 14, 2016. The Zoning Commission voting unanimously to adopt text to revise the DC zoning regulations and approve map amendments to implement the text. It was the first time zoning regulations and zoning map were comprehensively revised since 1958. The DC Office of Zoning held over 100 trainings, community meetings, public hearings, and public meetings to address concerns, gather feedback, provide information, deliberate, and afterwards pass regulations. I'm not suggesting this process needs to take 9 years, but rather highlighting that this is a major reform that requires equally thoughtful deliberation around implementation. Hearing from the actors who will implement the law, and most importantly, hearing from the community who it will impact. The executive looks forward to continuing to work with the council, our public safety and justice ecosystem partners, and our residents to ensure we have a justice system that is advancing the administration of justice while also advancing the safety of our residents and city. I'll be here for any questions, sir.
Thank you, Deputy Mayor. Next, let's go to Paul Butler, who is the Albert Brick Professor in Law at Georgetown University Law Center. Good morning. Mr. Butler, I'm sorry, I think you're muted. I think we're still muted. Let me see if my staff is able to help out from their end either. Sometimes I've found under the microphone, and what we could do, Mr. Butler, if we need to take just a second to figure this out, I could turn to Mr. Brayman and then we'll come right back to you in a moment once we figure that out. Does that work for you? Okay. All right. So what we're going to do then, we'll come right back to Mr. Butler in a moment. So next, let's turn to Donald Brayman, Associate Professor of Law at the Georgetown Washington University Law School. Mr. Brayman, let me turn to you. Good morning.
Thank you, Chairperson Allen and members of the Committee on the Judiciary and Public Safety for holding this hearing and for allowing us all to testify regarding the RCCA. First, I want to say that for a jurisdiction revising a criminal code, this is how it should work. Although it's been an incredibly laborious process, it's in no small part because it's been so methodical and so transparent. The Commission took stock of considerations from many, many stakeholders and national experts. The Commission published every interim draft and finding and made sure that stakeholders had every opportunity to weigh in. The amount of work that Director Schmeckel and his staff put in developing detailed reviews of every aspect of this bill and then soliciting feedback and integrating discussion and suggestions is staggering. What the district is doing here is a model for any other jurisdiction in the country, and the district should be very proud of this process and this work. Today, I do want to focus on felony murder. Among experts in criminal law, there is nearly universal disapproval of felony murder doctrine as it exists in the district. And the trend is to disallow felony murder or dispense with felony murder in the first degree altogether. I want to lay out why first degree felony murder should be dispensed with and why the proposed version, which restricts its use to second degree murder and disallows its extension via accomplice liability, is not only appropriate, but the only reasonable option short of eliminating felony murder doctrine altogether. The short version of my testimony is this: the district's current felony murder doctrine treats people who have no intention of killing anyone like the most heinous intentional murderers in our system, breaking the normal considerations of proportionality that should inform gradation in a criminal code. It should be abandoned as the broken and iniquitous doctrine that it is, and replaced with the reformed version drafted in the proposed code, or simply removed altogether. Felony murder treats those who accidentally cause death during certain felonies as if they intended those deaths with malicious premeditation. And it may seem appealing at first in some ways, but as experts and judges who have to deal with the consequences of the doctrine across the country observe, close inspection reveals that felony murder doctrine, and first degree felony murder doctrine in particular, injects incoherence into the law in ways that are just unacceptable. Why is incoherence an inescapable part of first degree felony murder doctrine? The answer has to do with the careful gradations that are built into the rest of homicide doctrine. Intentional homicides typically must also consider various mitigating circumstances that spell out the difference between murder and voluntary manslaughter. In order to retain both self-defense doctrine and voluntary manslaughter doctrine, felonies that are part of most killings, crimes like felony assault, cannot be used as a predicate to support a first-degree homicide charge. If this were not so, then nearly all intentional killings would end up as felony murder because they also constitute felonies other than murder. And in the most obvious, but hardly the only case, if felony assault were allowed to trigger felony murder, then all intentional homicides would be first-degree murder under the current doctrine. As a result, in every jurisdiction, courts and legislatures have to restrict the predicate felony so that it's not too commonly associated with killing. And instead, these types of felonies are said to merge with the murder charge and thus cannot be used as predicates to felony murder. The predicate felonies also can't be too distant from killing, or it will seem arbitrary and unjust to convict someone of murder rather than manslaughter. Thus, felonies that are not inherently dangerous, like fraud, cannot be considered as predicates to felony murder either. Invariably, what's left is a strange grab bag of felonies that are not too close to premeditated murder and not too distant from premeditated murder, and which invariably makes for a set of bizarre gradations that, when taken as a whole, make little or no sense. Felony murder's bypassing of the key considerations that distinguish first-degree murder from other forms of homicide is what makes those who study the criminal law so distressed by codes that allow for this kind of imbalance. Consider the following two hypotheticals. In the first, a man enters a house to steal a stereo that he believes he should have gotten. In a divorce, he uses a knife to jimmy open the door and silently steal the stereo while his ex-wife and her new family are asleep. Unplugging the stereo, he unwittingly generates a spark that causes a fire that burns down the house, killing the entire family, including the two children. In the second scenario, a man breaks into the house by kicking in the door and with his bare fists brutally beats his ex-wife and her new family, including two children, to death. Both are very serious crimes and deserve punishment, but under no principled theory of punishment should they be considered equivalent. And yet, under the district's current felony murder doctrine, these two crimes are both first-degree murder. What's more, having proven the facts outlined, the job of convicting the second defendant of first-degree murder is actually much harder for the prosecution than the job of convicting the first defendant, because all the traditional proof requirements of premeditation, deliberation, and possible mitigating circumstances relating to the mental state must also be considered. And to make a bad doctrine much, much worse, it is possible to convict people of felony murder when they have no intention of killing and do not kill anyone, so long as they are involved in a felony as an accomplice that results in death. Thus, if the stereo burglar's girlfriend knowingly assisted him in stealing the stereo, say by driving him to and from the house, she too would have committed first-degree murder via accomplice liability. Why would anyone advocate on behalf of our current felony murder doctrine if it is so dysfunctional? In practice, the only benefit of the district's current felony murder doctrine is the greater discretion and power it provides prosecutors over charging in a significant minority of homicide cases. And prosecutors defending felony murder doctrine across the country have been quick to point to examples of very serious killings where they have employed the felony murder doctrine as it exists on the books. But in truth, even if felony murder did not exist at all, prosecutors could have charged the same sets of facts under one or several serious alternative offenses, in most cases, including a form of homicide or attempted homicide that is equally or more likely more appropriate than first-degree murder. Prosecutors like over-inclusive felony murder doctrine because it reduces the work that they would have to do in order to make a first-degree murder case. But the fundamental property of proportionality in a criminal code is more important than prosecutorial convenience. Shortcuts in the criminal code, like felony murder, may appear simple in the abstract, but they cannot be justified on the whole. Short of removing felony murder from the code entirely, my recommendation, based on the policy considerations and consistent with other states that have reviewed and reformed their criminal codes, is that restricting felony murder to murder in the second degree and barring accomplice liability where the accomplice does not intend death is a reasonable reform. It addresses the major concerns about proportionality while retaining the doctrine itself. But to be clear, other jurisdictions have removed felony murder altogether and have not suffered any ill effects as a result. Several states, including most recently Illinois and Massachusetts, have made this reform. Lawmakers and judges in those states, through extensive analysis similar to that undertaken by our own commission here in the district, have reviewed and discarded the broken doctrine of first-degree felony murder. And in doing so, they join other states like Michigan and Kentucky, Hawaii, and Ohio, where responsible review led them to say goodbye and good riddance to this antiquated and iniquitous part of their law. In conclusion, consistent with nearly unanimous expert opinion and also consistent with reform efforts across the country, I recommend that the council adopt the reform code provisions addressing felony murder and related accomplice liability as drafted. Thank you. I will be available for questions.
Thank you so much, Professor Raymond. All right, now let's see if Paul Butler, we've got you unmuted now.
I am. Thank you, Councilmember Allen.
Excellent.
Ladies and gentlemen, good morning. My name is Paul Butler and I represent the United States. And I was a prosecutor. That's how I used to start my opening statement to the jury. Many years ago, I had the high privilege of serving as a special assistant United States attorney in the District of Columbia. I prosecuted misdemeanor crimes. During that time, I learned some things. I learned two lessons that have informed my work as a scholar and teacher and proud citizen of the District of Columbia. Those two lessons inspired my testimony this morning about the urgency of the revised Criminal Code Act. The first lesson I learned was about juries, and I had to learn it the hard way. After my service in the U.S. Attorney's Office, I moved to Main Justice, where I prosecuted public corruption cases. We were prosecuting a United States senator for stealing money from taxpayers. While I worked in that case, I got arrested by the DC Metropolitan Police Department and prosecuted by the U.S. Attorney's Office, the same misdemeanor squad that I worked for. I was prosecuted for a crime I did not commit. Simple assault, a misdemeanor. I remember when we rookie prosecutors were in training for how to prosecute those cases, the boss joked, there's nothing simple about simple assault. I laughed then. I didn't yet understand that there is nothing simple about any accusation of a crime, even a misdemeanor. My case was literally called the United States of America versus Paul Butler. Imagine how you would feel. Understand how much the Constitution means to somebody in that situation, the guarantees of due process, equal justice, criminal laws that are coherent and fair. Imagine if it were the United States of America versus you, how crucial it would be to have a constitutional right to a trial by a jury of your peers, your fellow citizens in the District of Columbia. My case happened because of a dispute with a neighbor over a parking space. Even in the 1990s, parking spaces were at a premium in our city. My neighbor called the cop, told the cops that I pushed her. She showed them where I lived. The officers saw a young Black man and they arrested me. I hired the best lawyer in town, an African-American woman named Michelle Roberts, who had been the executive director of the District of Columbia Public Defender Service. PDS is widely considered the best public defender agency in the country. Ms. Roberts tried to get the prosecutors to drop the case, but they wouldn't, for what we later learned were political reasons, but they offered me a good deal, community service, and the case would be dismissed. No, I told Michelle Roberts, I am innocent. And then the best lawyer in the District of Columbia told me, you are a citizen of a country and a city where you have constitutional rights. Let's take this case to the people of the District of Columbia. We went to trial. 12 DC citizens sat as my jurors in my misdemeanor trial. The case took 2 or 3 days. The prosecution presented its evidence, and then I took the stand in my own defense. Afterwards, the jury was sent to deliberate. Less than 30 minutes later, there was a knock on the door. The jury probably has a question, my lawyer told me. But that one time, the best lawyer in the District of Columbia was wrong. The jury had a verdict. I'm not going to tell you what happened because I want you to read my book, Let's Get Free, where I tell the whole story. You can check the book out from one of our city's fine public libraries or purchase it from one of our great local bookstores. But I'll give you a hint. Things worked out fine. Many years later, in the Superior Court, my case was expunged on the ground that I was innocent. Things worked out because I had Michelle Roberts as my lawyer things worked out because as a resident of the United States of America and the District of Columbia, I had a right to a trial by jury. But that was in the 1990s. Then the law in this great city went backwards. Today, I would not have the right to a trial by a jury in the District of Columbia. In 1994, the same year that the US Congress passed the infamous crime bill of 94, this council passed its own crime bill. After great pressure from the prosecutor's office, the city council enacted the Misdemeanor Streamlining Act of 1994. It took away the right to trial by jury for people accused of most misdemeanors. Now, citizens of the District of Columbia do not have the same right to a jury trial as citizens in most states. This is not because of congressional interference by people who are opposed to self-determination in DC. It's our own city council that 30 years ago made DC residents less than full citizens. The framers of the Constitution understood the direct relationship between the right to trial by jury and democracy. In Maryland, in Virginia, the person who gets accused of a misdemeanor can be judged by a jury of their peers. People in the District of Columbia cannot. You heard that right. In DC, right now you can get locked up and serve time for a crime that you do not have the right to a jury trial. The revised Criminal Code Act of 2021 restores to people in the District of Columbia the same right to a jury trial that citizens have in 40 other states. It establishes a gradual process where people who are accused of misdemeanors for which there's prison time are entitled to have a jury decide their case. The act establishes a 3-year process to make sure that courts can restore our rights efficiently and with no cost to public service. Respectfully, the City Council should hear the words of Eric Washington, the former Chief Judge of the DC Court of Appeals. In a judicial opinion in 2018, Judge Washington strongly suggested that this council reconsider its decision to take away the right to a trial by jury. Chief Judge Washington was concerned about democracy and the Constitution and racial justice. He noted that if DC residents get back our jury trial rights, that would be an important message to send at a time when communities of color are openly questioning the system. And in the short time I have left, the second lesson I learned as a DC prosecutor was about racial justice. When I got arrested, I was taken to Superior Court to be arraigned. I had prosecuted cases in front of many judges, and I was thinking how embarrassed I would be if one of those judges recognized me. They didn't. When I was in the courtroom that day, I was just one of 100 Black men on the lockup list. That's one thing that has not changed between the 1990s and now. The men and women and children in the DC criminal legal system, the people who are awaiting trial or who are locked up, do not reflect the glorious diversity of our city. If you were to go to the DC Superior Court today, you would think that white people do not commit crimes. They are almost entirely absent from the criminal court. The murder of George Floyd ignited the largest social justice protest in the history of this country. And this national reckoning on race, President Biden has pledged to eradicate structural racism. That's the bias that's built in, including bias that is built into criminal law and police practices. The Code Revision Act advances that worthy goal. The act is not explicitly about racial justice or civil rights, but it takes some important steps towards bringing equal justice under the law to all citizens. Right now, the DC incarceration rate is about the highest in the nation. Almost everybody locked up is Black or Latinx. The act ends the draconian minimum sentences that throw the book at accused people without allowing our fine judges in Superior Court to do justice in individual cases. The revised code also allows judges to look at cases in which people have been incarcerated for more than 15 years and considering letting them come home, only if the judge finds that there's no threat to public safety. And Finally, the revised code reduces indefinite life sentences while still imposing what are extremely harsh sentences for the most serious offenses. For example, under the revised code, people convicted of murder can be sentenced to 40 or 45 years in prison. For Black men, that is effectively a life sentence, since our life expectancy in the District of Columbia is under 69 years. I respectfully suggest that there is much more that the City Council can do to make Black lives matter in the DC criminal legal system, but this act is an important first step. So to the honorable members of the DC City Council, you may not get to say, like I did when I was a prosecutor, that you represent the United States. But as you consider the revised Criminal Code Act of 2021, you have the opportunity to represent this great country and this great city's highest ideals and most important values. The right to a trial by jury for every crime for which you can go to jail, equal justice under the law. I respectfully urge you to pass the revised Criminal Code Act of 2021. Thank you, and I'll be happy to take your questions.
Thank you very much, Mr. Butler. Next, let me turn to, I should have said this at the front, we're gonna everybody testify that we're gonna come around to questions after that. So hold tight because we'll come back with questions for sure. Next, let me turn to Elizabeth Weiser, Deputy Attorney General of the Public Safety Division with the Office of the Attorney General for the District of Columbia. Ms. Weiser, let me turn to you.
Thank you, Chairman Allen. Good morning. As you said, my name is Elizabeth Weiser, and I serve at the Office of the Attorney General for the District of Columbia as the Deputy Attorney General for the Public Safety Division. I am honored to be before you today to speak on behalf of Attorney General Carl A. Racine and the Office of the Attorney General in support of B24-0416, the revised Criminal Code Act of 2021. At the outset, I'd like to acknowledge and thank Senior Assistant Attorney General Dave Rosenthal for his work on the Criminal Code Reform Commission. Mr. Rosenthal has been engaged in the criminal code reform effort since 2006, when he served on the Sentencing Commission. And since its inception in 2016, Mr. Rosenthal has been an advisory committee member to the Criminal Code Reform Commission. Over 4.5 years, from October of 2016, when the commission was created, to March of 2021, the advisory committee met 50 times. The meetings were open to the public. The recordings of the meetings and the members' hundreds of pages of comments and drafts of the recommendations were uploaded to the Commission's website for public review. This process has been open and transparent, with members exchanging views and reconciling different points of view. Over the course of years, the Commission tackled the Herculean task of dissecting an outdated, archaic set of laws and creating a modern, fair, internally consistent and understandable criminal code. The Attorney General is deeply grateful to Mr. Rosenthal and all members of the Commission for their work in this effort. This bill is the culmination of those efforts. Its passage would bring the district's criminal code into the 21st century. The bill will modernize our outdated and confusing code and bring fairness, proportionality, and clarity to our criminal justice system. As you know, the bill is the work of experts from across the criminal justice system: federal prosecutors, local prosecutors, public defenders, academics, and analysts. These experts met monthly for years, carefully analyzed and modernized our code, and voted unanimously to present the bill to the Council for its consideration. Not all the stakeholders agree with every aspect of the bill, and you are hearing some concerns today. But in considering the bill, it is important to remember the rigorous, substantive, and complicated process that was used to develop it. Some of the changes are bold, but they are critical to the modernization of our current code. Changes that make penalties fair, just and proportionate to the conduct being punished. Changes that give neutral judges more discretion to craft appropriate sentences, and that afford all individuals facing criminal charges the opportunity to have a jury of their peers determine their guilt or innocence. These policy changes are based on scientific data and research, and they reflect the values of district residents. There are a few parts of the bill that I would like to highlight. First, the bill recognizes the importance of judicial discretion and affords District of Columbia Superior Court judges more discretion than they have now. For instance, it enables mandatory minimum sentences. It eliminates mandatory minimum sentences for certain crimes, enabling judges to sentence people based on the nature of the crime, a person's criminal history and other background, and the impact on and views of crime victims. More fair, equitable, and just sentencing occurs when judges are permitted to exercise discretion when all facts are presented. Attorney General Merrick Garland might have said it best in his confirmation hearing when asked about how he would ensure racial equity and proportionality. He said, "We should seek the limitation of mandatory minimum so that we, once again, give authority to district judges, trial judges, to make determinations based on all the sentencing factors judges normally apply and don't take away from their ability to do justice." Second, I would like to highlight the bill's proposal to restore the right to a jury trial for all individuals facing a charge punishable with incarceration in the district. Depriving someone of their liberty is the most significant power we afford our government. And research demonstrates that even short periods of incarceration can have devastating consequences on someone's life. Even 3 days in jail can mean the loss of a job, housing, and parental rights, upending a person's life, a person's family, and increasing their future risk level. Additionally, a criminal conviction can change a person's ability to get a student loan, their employment prospects, and their housing options. A person facing conviction and incarceration should be entitled to one of our most precious constitutional protections, trial before a jury of your peers. The right to a jury trial is a fundamental right that was devised as a crucial check on the enormous power of the state. This is especially critical in the district, where the prosecutor of most crime charged against adults is a federal presidential appointee. Requiring that prosecutor to try a case to a jury of district residents provides a voice to the district in our criminal justice system. Limiting mandatory minimums and affording all individuals facing possible incarceration a right to a jury are just two of the important concepts in this bill that will make our criminal code more equitable and just. Advancing the bill will increase trust and faith in our justice system, and we are proud that the district is poised to make these reforms a reality. To be clear, the passage of the bill is just one important action we should take to advance fairness and public safety in our city. We must also continue to work to address the underlying issues that face the mostly poor people of color in the district, who are predominantly the people charged with and the victims of crime. True public safety comes through prevention and rehabilitation. It comes when we address housing and food insecurity, and when we make good on the promise of quality education, childcare, and medical and mental health services. The best chance we have to stop crime is to provide hope for safety and prosperity to those of us who struggle the most. Thank you, Chairman Allen, for providing the Office of the Attorney General with the opportunity to testify about this bill. We urge the council to move forward and pass this important legislation, and I look forward to any questions you may have after this round of testimony.
Thank you so much, Ms. Weiser. Next, we're going to turn to Laura Hankins, who's the General Counsel of the Public Defender Service for the District of Columbia. Ms. Hankins, good to see you and good morning.
Thank you. Good morning. Can people hear me okay? Is it okay? Thank you for the opportunity to testify at this hearing on Bill 24-0416, the Revised Criminal Code Act of 2021. I am Laura Hankins, General Counsel at the Public Defender Service for the District of Columbia. I was the PDS representative to the Code Revision Advisory Group. With me today is my colleague, Katerina Semyonova, who is the Special Counsel to the Director on Policy and Legislation at PDS, and who was my partner on advisory group work. It's good to be back before the Council discussing reforming the district's criminal code. I first testified before the Council on this subject on May 31st, 2005, at a public hearing on Bill 16172, the Criminal Code Reform Commission Establishment Act. The bill had been introduced by Councilmember Kathy Patterson as a result of her work grappling with aspects of the criminal code when she was chair of the Judiciary Committee. The May 2005 hearing was before then chair of the Committee on the Judiciary, Phil Mendelson. The committee report on the 2005 bill began by quoting Patricia Riley, then the special counsel to the U.S. Attorney, who had testified saying, Like any document crafted by different authors at different times spanning a century or more, the Criminal Code of the District of Columbia has some archaic, inconsistent, and occasionally confusing language, and some instances where the punishment does not fit the crime. A thorough review of the code is therefore in order, end quote. The committee went on to note in the report that it received no opposition to the bill and instead heard common themes from witnesses who testified in support of the bill. According to the report, one common theme of the witnesses was, and I quote, that the work proposed by this legislation will take time. 16 years and some months after I testified in support of the original Code Reform Commission bill, I'm back and pleased to express PDS's support for Bill 24-0416. I want to thank DC Auditor Kathy Patterson for introducing the original bill and thank Council Chairman Mendelson for shepherding that bill through the council when he was Judiciary Committee Chair. But more importantly, I want to thank Chairman Mendelson, who, when it became clear that as part of the DC Sentencing Commission's mandate, criminal code reform would never move forward, introduced amendments to create the DC Criminal Code Reform Commission with a more clear and reform-oriented mandate and structure. We would not be where we are today without Chairman Mendelson's 16 years of support for the Criminal Code Reform Project. Thank you also to Richard Schmeckel for having done an excellent job as the Executive Director of the Criminal Code Reform Commission, and to all the Commission staff, past and present, who worked on this project so tirelessly and sometimes through incredibly difficult circumstances. And thank you, Chairman Allen and your staff for holding today's hearing and the two previous hearings on this extensive and important bill, and for all the work you're doing to carry the bill across the finish line. Bill 24-0416 is an incredibly thoughtful and comprehensive legislative proposal that represents the careful study of other jurisdictions, best practices, and academic writings. While PDS very much supports passage of the Revised Criminal Code Act, we disagree with some of the recommendations made by the Commission and urge this committee in those areas to act more boldly. My written testimony includes the following: PDS's support for the provisions in the bill that would eliminate mandatory minimum prison sentences, expand the statutory right to a jury trial, and expand the resentencing provision commonly known as second look. My written testimony also addresses PDS's opposition to certain provisions in the bill and specifically urges the council to eliminate felony murder, reduce the proposed maximum prison penalties, and reduce the terms of supervised release. As PDS and the U.S. Attorney's Office often disagree, I want to start with an issue on which I am glad to say we finally agree. 6 months ago, at the December 21st, 2021 symposium held by the Criminal Code Reform Commission to discuss its final report, I was pleasantly surprised to learn that the U.S. Attorney's Office supports the elimination of mandatory minimum prison sentences as proposed by the Commission and as provided for in the bill. In voicing this position at the symposium, my fellow advisory group member, special counsel to the U.S. Attorney Alana Suttenberg, quoted Attorney General Garland, who said at his Senate confirmation hearing, quote, "We should do as President Biden has suggested and seek the elimination of mandatory minimums so that we once again give authority to trial judges to make determinations based on all of the sentencing factors that judges normally apply." PDS agrees. Ending mandatory minimums would increase sentence proportionality by allowing judges to individualize a person's sentence. And for felony sentencing in the district, we have the voluntary sentencing guidelines. Despite being voluntary, Superior Court judges overwhelmingly comply with the guidelines. Thus, mandatory minimum sentences are not necessary to achieve the goal of reducing unwarranted disparity between sentences or even of guiding the judge to impose some prison time for many offenses. PDS also supports the bill's expansion of the statutory right to a jury trial. In the 1970s and 80s, district law provided a jury trial if a person were charged with an offense that carried a penalty of more than 90 days. In 1992, in the name of efficiency, the threshold was raised to entitle a person to a jury trial if they were charged with an offense that carried a penalty of more than 180 days. 2 years later, in 1994, in the midst of the crack epidemic and a local budget crisis, the district passed misdemeanor streamlining and changed the penalty for most misdemeanors from 1 year to 180 days with the express purpose of depriving people of jury trials in misdemeanor cases. Having been given an inch, the U.S. Attorney's Office seized a mile to deprive people of jury trials by stacking misdemeanor offenses. For example, in one case, the U.S. Attorney's Office broke down a rape charge, which is a jury trial demand eligible offense, into 5 non-jury trial demandable misdemeanors. In response to the U.S. Attorney's Office misdemeanor stacking practices, the council passed the Misdemeanor Jury Trial Act of 2002 to require a jury trial where an individual faces cumulative incarceration of more than 2 years as a result of multiple misdemeanor offenses. In another complication in this body of law, in 2018, the DC Court of Appeals held in Botto versus United States that the Sixth Amendment entitles a person to a jury trial, regardless of the maximum prison sentence they face, if the person is charged with a criminal offense that could result in their deportation from the United States. The district's current jury trial laws make our jurisdiction one of the most restrictive places in the country for jury trial rights. And jury trial rights depend on citizenship status, with US citizens being deprived of jury trial rights despite being charged with misdemeanor offenses that, in addition to incarceration, may require sex offender registration and may create significant barriers to employment, education, and housing. Ironically, despite being a place that prizes democratic principles of representation and laments their absence, the district deprives residents of the essential right of trial by jury in the service of efficiently obtaining convictions that affect the district's Black residents with gross disproportionality. One of the changes that I've been really glad to see take place in the district and on this council is a growing realization that justice does not have to mean imprisonment for as long as possible, and that mercy does not have to be doled out in teaspoons. The criminal legal system needs safety valves. There should be fewer on-ramps into the system and more off-ramps out of the system to provide for justice and mercy. Prosecutors, and certainly not the federal prosecutors who are unaccountable to DC residents, should not be the gatekeepers for all of the mercy and non-criminal outcomes possible. There should be statutes that authorize the courts to also act as gatekeepers, giving judges the discretion to close an on-ramp into the system, for example, through the authority to dismiss cases that caused minimal or unforeseen harms, and giving judges the discretion to open an off-ramp or safety valve out of the system, for example, through an expanded second look provision. A second look provision with no age restriction would be a powerful safety valve. Such a provision recognizes that rehabilitation is possible. Moreover, it incentivizes rehabilitation and programming during incarceration. People can change a lot over the course of 15 years. The 33-year-old changed since they were 18. The 40-year-old isn't the same as they were at 25, nor is someone the same at age 60 as they were at age 45. If the district had to use district dollars rather than federal funds to incarcerate people as they near eligibility for Medicare and Social Security, the need for a second look provision would be beyond debate. A second look provision provides a second chance. Such a provision merely allows a judge to consider on an individual level whether release is now appropriate. It humanely ends an obsession with finality that consigns district residents to dying in prison because it seemed like the right sentence 15, 20, or 40 years ago. PDS disagrees with the approach taken by the Criminal Code Reform Commission with respect to felony murder and urges this committee to amend the bill to eliminate federal felony murder entirely from the district's criminal code. Admittedly, the proposal in the Revised Criminal Code Act is an improvement upon the current law. The bill would abolish the manifest injustice of holding a person responsible for a death that their co-defendant accidentally caused. That expansive application of felony murder has resulted in extremely lengthy sentences, including life, for persons who never possessed a weapon and who never intended or acted to physically harm anyone. The problem with Revised Criminal Code's approach to felony murder is that negligence is too low of a mental state to result in a murder or even a manslaughter conviction. This is not recklessness, where the person is aware of a substantial risk, disregards that risk, and engages in the conduct anyway. Negligence means that the person should have been, but was not aware of a substantial risk that their conduct would result in death. The death is essentially an accident. It should therefore not be punished as murder. If a person purposely or knowingly caused a harm, or a person acted recklessly as to the harm that would result, generally our society adopts a retributive notion of justice, that the person deserves some punishment for their conduct. However, imposing the same punishment on a person who accidentally causes a harm as you would impose on a person who knowingly causes that harm is not justice. And that's what felony murder does. Punishes a person for causing an accidental death to the same extent that we punish a person for knowingly causing someone's death. In instances where an individual negligently causes a death while engaging in a serious felony, the person can be convicted and punished for the felony and also for the offense of negligent homicide, an offense that the revised criminal code would expand beyond our current law. Because it is overly punitive and unjust, PDS urges this council to eliminate the offense of felony murder in the district. PDS recommends that the council reduce the statutory maximum penalties for the felony classes. While the revised Criminal Code Act appears to take a bold step by lowering some statutory maximum penalties, it only appears bold in the context of the draconian sentences our system now allows. If you read the commentary accompanying the statutory recommendations submitted by the Criminal Code Reform Commission and undergirding that bill, you will see that the 45-year penalty for Class 1 offenses is arrived at by determining a person's life expectancy, and not just any person. The Commission's frank acknowledgement that the district excels at incarcerating Black men in particular lays bare the rot, the racism, and the cynicism about the district's criminal legal system that we complacently accept. The proposed statutory maximum penalties in the revised Criminal Code Act, by acknowledged intention, create a system that sets penalties based on ensuring the possibility that the punishment for a single offense can be longer than the life of the person being punished. To quote the commentary explaining the proposed statutory maximums, quote, bottom line, based on current life expectancies without early release, a sentence of the RCC Class 1 and Class 2, maximum penalties would result in many, if not most, of the persons so incarcerated dying while in prison. The life expectancy statistics in the revised criminal code commentary are important, however. Rather than use them to justify penalties that are effectively death sentences, the statistics should justify lowering the maximum sentences. PDS joins witnesses who testified at previous hearings on this bill, as well as scholars and researchers who call for setting the absolute maximum sentence for an offense at no more than 20 years of incarceration. Ultimately, Bill 24-0416 is a significant achievement. In passing it, the council would create a criminal code that is coherent, comprehensive, and statute-based. As the 2005 committee report said, this project took time, but it was time well spent by an excellent commission that benefited from the advice of experts. PDS urges the passage of the bill.
Thank you very much, Ms. Hankins. And again, Ms. Simonova, you're going to be available to help answer questions, but didn't have testimony yourself, correct? Okay, thank you.
Correct.
Thanks. All right, then next, let me turn to Elena Suttenberg, who is the special counsel to the U.S. Legislative Affairs with the U.S. Attorney's Office for the District of Columbia. Ms. Suttenberg, good to see you, and I'll turn it over to you.
Good to see you, Councilmember Allen. Chairman Allen and members of the council, my name is Ilana Suttenberg, and I'm the special counsel for legislative affairs at the U.S. Attorney's Office for the District of Columbia. I thank you for the opportunity to appear at today's public hearing regarding the revised Criminal Code Act of 2021, or the RCCA. USAO supports the goal of reforming the DC Criminal Code to ensure that statutes are clear and consistent, logically ordered, and proportionate in their penalties. In many ways, the RCC is consistent with that goal, and we appreciate the council considering these recommendations further. The RCCA is the product of a tremendous amount of work by the DC CCRC Executive Director, CCRC staff, and advisory group members, and we recognize their efforts. The RCCA creates many positive reforms to the criminal code and is an important part of criminal justice reform in the district. USAO participated as a member of the CCRC advisory group, and we voted in favor of submitting the final recommendations to the council and the mayor. At the time of the vote, however, we were clear that our vote was not intended to express support for all of the CCRC's recommendations. While we were supportive of moving this process forward, we believe that there are some substantial remaining issues that should be addressed before the council takes final action. Our most significant concerns focus on accountability for the most violent crimes, such as child sexual abuse, murder, burglary, robbery, and carjacking, and that some of the RCCA proposals are not integrally related to substantive criminal law and overlook the realities of certain resource constraints impacting Superior Court and our office. My testimony today will highlight those significant concerns, and my subsequent written testimony will address additional concerns. Initially, there are several provisions that are not integrally related to the substantive criminal law that the CCRC was tasked with revising. These provisions should be disaggregated from the RCCA and considered on their own merit as separate legislation. A reform of the substantive criminal laws is already a tremendous endeavor that will have a significant impact on the criminal justice system. The RCCA should focus first and foremost on these substantive criminal laws, and the council should consider these additional procedural provisions, if at all, once the criminal justice system has responded to the RCCA's impacts. Even though we believe that these provisions should be disaggregated, we offer the following concerns. First, the RCCA proposes dramatically expanding the right to a jury trial for misdemeanor offenses, such that within several years, all offenses punishable by any period of incarceration would be jury demandable. We respect the right to a jury in appropriate cases, including all felony cases. Jury demandability requirements for misdemeanors, however, should remain consistent with current law. When considering any changes to the jury demandability provisions, we strongly encourage the council to closely engage with DC Superior Court to understand their resources, their funding, and how any change would both directly impact cases on the criminal dockets and indirectly impact cases on other dockets through the diversion of resources. Given the import of this change, we would encourage the council to seek testimony on this proposal from DC Superior Court. Under non-pandemic court operations, there are approximately 3 to 5 misdemeanor cases scheduled for trial every day in each of the 6 general misdemeanor courtrooms, and approximately 2 trials a day in each of the 2 domestic violence misdemeanor courtrooms, roughly 110 to 170 misdemeanor trials scheduled per week. By contrast, there's approximately 1 felony case scheduled for trial every day in each of the 8 felony courtrooms, about 40 trials a week, and approximately 1 felony case scheduled for trial per week for the 4 to 5 calendars that handle the most serious felony cases, including sexual abuse and murders. Creating new rights to demand a jury in misdemeanor cases will strain both court and prosecutorial resources. Jury trials typically take longer to complete than bench trials and must be scheduled farther in advance than bench trials. Consequently, creating additional misdemeanor jury trials will require more judges, more jurors, which would result in DC residents being called for jury duty more frequently, and additional prosecutorial resources. Further, felony cases, especially felony cases involving a detained defendant, are typically prioritized for trials in the court system, so it will likely take longer for misdemeanor cases to go to trial. This may result in delayed justice for victims, as victims will invariably need to wait longer for cases to resolve at trial, even in relatively straightforward misdemeanor cases. To our knowledge, no one has begun to analyze what it would take to create the infrastructure to handle a 2 to 4-fold increase in the number of scheduled jury trials, what constraints exist that are beyond the district's control, such as the current size of Superior Court, and what delays in justice could ensue from all these changes. Given the consequences involved, these issues should be analyzed and discussed before any action is taken. Next, the RCCA proposes that for every misdemeanor, when a defendant is found guilty of the offense, the court may defer further proceedings and place a defendant on probation before judgment for a period not to exceed 1 year. Under the proposal, if the defendant does not violate any of the conditions of probation, the court shall dismiss the proceedings, and following a dismissal, the defendant may move to seal the arrest in court proceedings. We support the desire to expand diversion for low-level offenses in recognition that a conviction may not be the most fair and just result in all cases. Consistent with that recognition, we've been working to expand our pretrial diversion program with the goal of maximizing public safety, reducing recidivism, and enhancing a fair and efficient criminal justice system. The RCCA proposal, however, would allow judicially crafted diversion after a trial or guilty plea for all misdemeanor offenses, including the most serious misdemeanor offenses, such as certain sex offenses involving adult and child victims, domestic violence, stalking, and voyeurism. To guide our diversion, we have detailed internal guidelines for which defendants are eligible for these diversions, which helps ensure similarly situated defendants are treated the same, and the types of diversion opportunities that should be available for a particular defendant. In short, we have a standardized system for identifying defendants who could benefit from diversion and then offering them the most appropriate diversion opportunity. By contrast, there have been no developed guidelines regarding the implementation of judicially led diversion, including what types of diversion may be most appropriate for a particular defendant or case. We want to ensure that our pretrial diversion program is robust, allowing for the most appropriate plea agreement or diversion opportunity and creating consistency between cases. This proposal may undermine our ability to accomplish that goal. Next, the RCCA proposes expanding the second look provisions to allow any person, regardless of their age at the time of the offense, to petition the court for review of their sentence after the person has been incarcerated for 15 years. We recommend that the council delay consideration of this proposal. We recognize that the goal of a sentencing review mechanism is to offer second chances and to ensure that people who have served their time have opportunities for rehabilitation and re-entry. This proposal, however, would expand second look review from current law, which was significantly expanded by the council earlier this year. Based on data obtained from BOP this past summer, there are currently 460 people in BOP custody who became immediately eligible to apply for a sentence reduction as a result of the recently enacted Second Look Act. Expanding this to permit a universal second look would allow an additional 335 individuals in custody of BOP who were 25 or older at the time of the offense and have served 15 years incarceration to immediately move for release. Given that this pool of eligible individuals was so recently expanded, we encourage the council to delay further consideration of any additional expansion. Before any additional expansion, we should review the impacts of this expansion, including offenses, particularly violent offenses, committed by people released under this provision, the impact this expansion has had on victims and their families, the supports available to assist victims with navigating this process, and the supports available to assist individuals released under this provision with reentry and reintegration to society. Next, I'm going to discuss some concerns with the substantive criminal law proposals proposed by the RCCA. First, as to burglary. The RCCA proposes creating 3 gradations of burglary. First-degree burglary, which requires that a victim directly perceive the defendant inside a dwelling, would be punishable by a maximum of 4 years incarceration. An enhanced first-degree burglary, committed with a firearm or dangerous weapon, would be punishable by a maximum of 8 years incarceration. These proposed maximum penalties, however, do not adequately account for the harms and trauma that can be incurred by what is, in essence, a home invasion. A statutory maximum does not represent the legislature's sense of what the minimum amount or even average amount of punishment associated with a crime should entail. Rather, a statutory maximum, by definition, reflects the legislature's belief as to what a person should be sentenced to for committing the worst possible version of that offense. Homes are where people live, where they keep their children safe, where they store their most valuable and sentimental possessions, and where they feel most secure. A burglary can shatter this sense of security, sometimes irrevocably. The maximum penalty for this crime, therefore, should recognize that a burglary violates the sanctity of this home, and the maximum penalty should be increased so that it is commensurate with the harms that can be caused by this type of invasion. The RCCA proposal represents an unwarranted departure from current law. Next, the RCCA proposes creating 3 gradations of robbery, depending on the level of bodily injury suffered by the victim and the type of property that was involved. A robbery that did not result in serious or significant bodily injury and where the property taken was valued at less than $5,000 would be categorized as third-degree robbery with a statutory maximum of 2 years incarceration. Committing this offense while armed with a firearm would be categorized as enhanced third-degree robbery with a statutory maximum of 4 years incarceration or a higher maximum penalty if the firearm actually caused bodily injury to the victim. The RCCA also proposes subsuming the offense of carjacking into robbery. Unarmed carjacking as second-degree robbery would have a 4-year maximum, and armed carjacking as enhanced second-degree robbery would have a maximum of 8 years incarceration. While we could support reductions in the maximum penalties for these offenses from current law, the proposed reductions are simply too great. The maximum penalty for carjacking should recognize that carjacking is akin to burglary in some ways, as it may involve a traumatic intrusion into a person's personal and presumed secure space. It also results in the loss of what is often a much more significant asset than is lost in another form of robbery. Further, the proposed maximum penalties for robbery and enhanced robbery are insufficient to account for the harms that can be incurred in a robbery, particularly where the robbery is committed while armed with a dangerous weapon. For example, under the RCCA proposal, both a defendant who held a gun to a victim's head and threatened to kill the victim in connection with a robbery, and a defendant who fired a gun indiscriminately at a victim but did not hit the victim because of bad aim, could each be sentenced to a maximum of 4 years incarceration for that offense. The RCCA's proposed departure is again unwarranted. Next, the RCCA proposes eliminating accomplice liability for felony murder. It also proposes requiring that for felony murder, the lethal act be committed in the course of and in furtherance of committing or attempting to commit the predicate offense, and proposes limiting the predicate offenses for felony murder from current law, including eliminating certain types of child physical abuse and other serious crimes as potential predicates for a felony murder conviction. However, we recommend that with respect to accomplice liability, the council adopt a compromise position and create an affirmative defense to felony murder. Under this affirmative defense, a defendant would not be liable for felony murder if the defendant could prove that they did not commit the lethal act and either believe no participant in the predicate felony offense intended to cause death or serious bodily injury, or made reasonable efforts to prevent another participant from causing the death or serious bodily injury of another. Notably, creating such an affirmative defense is consistent with a previous recommendation of the CCRC. This compromise position recognizes that accomplice liability for felony murder is necessary in many situations, because even where it is possible to prove the identity of the perpetrators of the offense, it is often not possible to identify the specific offender who committed the lethal act. Without some form of accomplice liability, crimes committed by multiple perpetrators would escape felony murder liability, while the same offense committed by a single perpetrator could result in felony murder liability. For example, a gang rape perpetrated by 2 or more individuals that resulted in the victim's death may result in no liability for murder, as it may not be possible to determine which defendant committed the lethal act. A father and a mother both systematically abusing their child, resulting in the child's death, may result in no liability for murder. Where 2 individuals fire gunshots at a victim at the same time in the course of an armed robbery or carjacking, and it is impossible to prove which bullet caused the victim's death, there may be no liability for murder. These examples show the necessity of accomplice liability for felony murder in situations where its absence would otherwise mean that neither person responsible for killing someone in the course of what is an inherently dangerous and violent offense is held accountable for murder. In murder cases, unlike for other offenses, the murdered victim cannot provide any information about what happened during the offense. By altering liability for accomplices under a felony murder theory, the RCCA proposal would effectively remove murder liability for certain felony murders committed by groups of perpetrators. Indeed, the more people who commit the predicate offense together, the less likely it would be that liability could attach for felony murder. Next, the RCCA proposes departing from long-standing district law that mistake of age is not a legal defense to child sexual abuse, and proposes creating an affirmative defense to felony child sexual abuse, where the victim is 14 or 15 years old, the defendant reasonably believes the victim is 16 or older, and the reasonable belief is based on an oral or written statement that the victim made to the defendant about the victim's age. For less severe forms of child sexual abuse, the government would be required to prove as an element that the defendant was reckless as to the victim's age. However, because this defense would allow for the introduction of evidence regarding the defendant's objectively reasonable belief as to the age of the victim, the existence of this defense could practically create a legally sanctioned justification for the defense to introduce evidence that would otherwise have no probative value at trial. For example, to show an objectively reasonable belief, the defendant may seek to elicit testimony relating to the child victim's appearance, including the child victim's physical development, maturity, and clothing, or photos of how the child victim presents themselves on social media. This testimony would be elicited to show why the victim appeared to be older than the victim's true age. Allowing evidence of the defendant's reasonable belief would allow this type of demeaning and humiliating evidence to be deemed probative at trial and thus admissible at trial. If this proposal goes into effect, a defendant may also seek to introduce evidence currently precluded by the rape shield law regarding the victim's prior sexual behavior to validate their reasonable belief that the child victim was of consenting age. Such evidence could include, for example, the victim's known history of engaging in sexual acts with adults, prior pregnancies or births, involvement in prostitution and or other sexually related behavior of an adult nature that suggested to the defendant that the victim was of a legally mature age. This evidence is the exact type that exposes the extremely intimate life of the victim, and here a child victim, that the rape shield law was specifically designed to exclude, except in the most unusual cases where the probative value of the evidence is precisely demonstrated. We account for compelling fact patterns in exercising our charging discretion, where despite the strict liability for this offense, a person may have reasonably believed that a victim was not underage. Allowing for this legal defense, however, may permit the victim to elicit evidence at trial in a manner that is inappropriate, unnecessarily humiliating for the sexual assault victim, and directly contrary to the compelling policy reasons behind the rape shield law. Next, the RCCA proposes adding the modifier sexually to certain conduct before it can constitute a sexual act or sexual contact, such that certain behavior would only constitute a sexual offense if the defendant has a sexual intent. However, adding the modifier sexually would constitute an ill-advised change from current law, as it would unduly limit situations where the defendant's conduct should qualify as a sexual act or sexual contact. Sexual violence can be about power and control, not sex or sexual gratification. When committing a sexual offense, a defendant may be motivated by a desire to be violent or to assert power over a victim, not necessarily to be sexually aroused. For example, if at a fraternity or sorority hazing, a defendant publicly penetrated another person with an object, the defendant may not have been acting with a sexual desire, but may have been acting with an intent to abuse, humiliate, harass, or degrade the victim. This would and should constitute a sexual offense. Further, even where a victim clearly experiences a sexual violation, it is often difficult, if not impossible, to prove that a defendant committed the offense for a sexual reason. For example, if a defendant grabs the vagina, breast, or buttocks of a stranger, that victim likely will feel sexually violated, and the conduct should constitute a sexual offense. Absent evidence of outwardly manifesting sexual pleasure through words or actions, which is rare in many cases, particularly those involving sudden, brief sexual assaults of strangers, the government may not be able to prove that the defendant's actions were sexually arousing or gratifying. The government, however, would be able to show that, at a minimum, the defendant intended to humiliate, degrade, or harass the victim. Last, as to mandatory minimums, the RCCA proposes eliminating all mandatory minimums from the DC Code. While we recognize and agree with the desire to reduce the number of mandatory minimums, we cannot support eliminating them all and argue that 2 in particular should remain in light of their direct relation to serious violent crime. First, the 30-year mandatory minimum sentence for premeditated first-degree murder should be maintained. District law has long provided for a minimum sentence for first-degree murder, an offense that is uniformly viewed as the most serious offense. Every state has some mandatory minimum for first-degree murder, and the concern that a mandatory minimum sentence may lead to a disproportionately harsh sentence for a less serious offense does not apply to first-degree murder. Second, the 5-year mandatory minimum for committing a crime of violence while armed with a firearm should be maintained. Under the RCC's proposed structure, a 5-year mandatory minimum sentence should attach to an enhancement that involves a dangerous weapon or imitation dangerous weapon, where 1, the underlying offense is a crime of violence, and 2, the weapon involved was a firearm or imitation firearm. This would attach a mandatory minimum to offenses such as armed carjacking, armed sexual assault, armed robbery, and armed kidnapping, but would not extend a mandatory minimum to drug-related offenses. The presence of any firearm is inherently dangerous and can create a significant risk of violence, including a risk of violence to both intended and unintended victims, and the presence of that firearm during a crime of violence necessitates a proportionate response. A minimum sentence reflects the community and the legislature's sense that committing a crime of violence while armed is unacceptable by community standards and will be penalized accordingly. In sum, USAO is committed to continuously seeking to improve the criminal law and criminal justice system in the district and looks forward to continuing to engage the council and the community in a discussion of how to make our criminal law more fair and just for all. And I'm happy to answer questions. Thank you.
Thank you very much, Ms. Suttenberg. And thanks to this entire panel. A lot of really fantastic testimony and your recommendations. So I appreciate everybody taking the time to do that. What I'm probably going to do is maybe start with a couple of, I don't know, I think maybe kind of focus on some process type of questions and then kind of go into some of the detail by detail items. Director Schmeckel, I'm probably going to begin with you if I can. You've obviously talked in our previous hearings about the district's efforts to modernize the criminal code, most recently through the Criminal Code Reform Commission, but also prior to your agency even being formed. Just to help again lay out the groundwork here, can you talk about the code reform efforts prior to the creation of the CCRC a little bit more? Because what I want to do is just make sure we have on the record what the substantive process looks like. How are stakeholders been involved? What's been expected? How they contributed? Things like that.
Absolutely. And you said focus on before the formation of the CCRC?
Before that, and then once you had the CCRC, in what ways that, what changed, what differed? That.
Sure. So I'll have to speak to things that I've only heard about or read about, because the code reform efforts, as mentioned before, go back to 2006 when legislation was first passed. And my understanding is that initial mandate to what was then the DC Sentencing and Criminal Code Reform Commission did not come with additional funding for staffing. So there were some years there where there was a struggle, I think, in that agency to deal with the very large task that they were given. After some time, though, funding was given, again, primarily through the leadership of Chairman Mendelson, or then Chairman Mendelson, who had moved on from being Judiciary Chair, to say, you need funding, you need staff to do this, okay, and saw that it happened. The agency was given staffing. As part of that, I was brought on in late 2012, and we were able to start to hire up staffing in 2013. So there was a big change there. Again, throughout that time, the commission had the mandate, had meetings, had some very, I think it was one position that was working on criminal code reform with the commission members who are an array of government criminal justice organizations. All the folks on this call, they or their organizations were involved, as well as MPD, many others. So from the get-go, right, involved in this discussion. What ended up happening, though, was, from my perspective, at the Sentencing Commission, was there was not agreement. Finding consensus on these matters is extremely difficult, as you've heard. The many different views and the high stakes, right? There was not consensus on how to move forward. And in that organization, the principals of that organization made the decision that without consensus, that was it, that we couldn't find a way forward. As a result of that, the CCRC was created. The council did not take no for an answer, as it were, and set up our organization. Some other staff then at the Sentencing Commission were redesignated to stand up a new temporary, at that time, agency, the Criminal Code Reform Commission. We hit the ground running. We had a much more control over how quickly the process would move. And we proceeded then to hold monthly meetings. And I think one of the other witnesses testified, over the course of the 4.5 years from late 2016 to the approval of the statutory language in March of this year, 2021, 4.5 year span, we had about 50 meetings. And, I think it was all but one of the advisory group members were there for the majority of the meetings, right? There was, very active participation, varied a bit by member. But not only was it participation in these public meetings, right? Recorded, noticed, we followed the district's Open Meeting Act, but they also were providing written comments. We had individual meetings with the institutional members of PDS, OAG, USAO with their staff. We had calls. We just both formal and informal, in written and oral. Just a tremendous amount of feedback in developing drafts. Each draft went through at least two, usually more iterations to get to the final product that was delivered. And in the course of that, we addressed the different concerns and positions of folks. Obviously, there were irreconcilable views by some of our advisory group members. You've heard them today, right? Some very different perspectives. And these are matters which I certainly is occupying a certain middle ground of sorts. I would say, reasonable minds can disagree on a number of these matters. But throughout this, we took a hard look at evidence. Statistics from DC Superior Court were provided to all the advisory group members. We provided some BJS surveys of how other states work out in sentences. We conducted again.
So actually, I want to kind of drill in that just
Sure.
a little bit. Throughout, I think, and I've said it before, I will extend again my gratitude to every partner, that's been a part of these meetings, just really having good, honest push and pull and back and forth, trying to kind of pull this together. So even when, as you said, reasonable people may have reasonable disagreements, there was just a lot of work that went into it around the table. So everyone appreciates that. But I guess, can you talk a little bit more about, because invariably, and I think you've touched on this, you will have advisory groups members' recommendations that would cut in different directions. And I want to make sure we lay out how did the CCRC, like what sources would you go to? What would your team consult when trying to weigh those options? And again, hearing those reasonable disagreements, where did you turn to? What type of sources, what type of materials did you turn to?
You bet. So our statute laid out several sources, right? And so we went to model penal codes. What is often referred to as the model penal code in the United States is a document initially produced in the early 60s, but has been more recently updated this last decade as to sentencing, which is obviously critical matter. So many of the things that were raised here in the testimony today are matters of that recent set of expert recommendations. I could talk more about why that is authoritative. It really is. But in addition, there are recent model penal code changes to sex assault provisions. Those too have now been cleared by the organization and its many, many experts through years and years of development. And they too reflect the positions by and large, and certainly the two that were singled out today in witnesses' discussion. The CCRC has followed those. So we have looked to these expert model recommendations out there in the literature. We have looked primarily in all of our work at current district law. As per our prior hearings, I tried to describe how the current state of the code is such that you often can't look to the statutes to see what the elements of an offense are. You have to look to the case law. You have to be a criminal attorney who's willing to put in a lot of work to uncover this. So we spent a lot of time looking at that case law and providing and showing how any changes to the law affect current district law. That was the focus of a legal commentary we put together, developed with the advisory group. And it's a massive reference document that was approved by this advisory group along with the statutory language in March. So we have this very large legal commentary that describes how district law was changed, because that throughout was a major consideration. We also, again, looked at statistics coming from DC courts. We looked at statistics from other jurisdictions. And we tried to work to accommodate as much as we could the different perspectives. At times, again, very different views on this, on particularly on some penalty matters. Happy to discuss those more, right? That's why I tried to focus on our process there in my own testimony, because we tried to take a systematic, logical approach to this. But we also recognize that there are many other points of view. And certainly, it's an area where I think, the council will want to look very closely and consider, what is an appropriate approach to incarceration penalties at this day and time.
Yeah. All right, thank you. And one other thing I wanted to ask you about, to share a little more detail, is you'd mentioned surveying district voters on their thoughts on criminal penalties. I want to ask you to share a little more detail about what that looked like. And what I mean by that is, how did you structure the survey? Who did you survey? You said voters. So was that registered voters? Was that just all residents?
Sure.
What were some of the more surprising results that you found? And I guess, you touched on this a little bit, but I'd like to expand a little further. How did survey responses diverge or align with district law or the CCRC recommendations?
Sure. So first, why did we do this, right? We did it because on the one hand, we have on the books these statutory numbers that were sometimes created 100 years ago, very different circumstances, different times, back when parole existed, very different context. They are often sharply out of sync with, I think, what anybody, all the representatives here on this in this hearing, and certainly the courts think should happen. What we see happening in court for sentences is much lower in general than what is authorized by statute, because again, they were created at a different time, often, providing really draconian sentences. That's what's on the books. So we looked at what was on the books. We looked at what's happening in practice, but even what happens in practice is very much confined and constrained by what is on the books. Most obviously for mandatory minimums, where there are mandatory minimums there, that constrains what current practice is. So just looking at what's going on in the courts now isn't necessarily a view of what judges actually think is proportionate. right? So we had to think, okay, how do we get beyond looking at just current court practice? And while there have been some other efforts, other organizations to survey, lawyers or attorneys or judges, we tried to go to the public, right? We contracted with YouGov, major survey organization many have heard of. We worked with them, and they have an assembled panel, again, demographically representative. So it's weighed in terms of income level, racial diversity, gender balance. And using this panel, we presented this array of questions, right? And you asked specifically about voters. The criterion for participation in that did include registered voters. So it's a pool, right? And by including registered voters, some voices were left out, right? And in general, as with any survey mechanism, it's to be taken with a grain of salt. Those surveys were conducted a few years ago now, about 3 years ago now, most of them. And the attention to criminal justice reform issues, the murder of George Floyd, so much has happened, right? And so I think when looking at those survey results, you have to also take that into account. They're already somewhat dated. But what we saw the people saying were some very different values than are reflected either in the current code or in current court practice. And they were things that have been discussed today. Specifically what the U.S. Attorney's Office has mentioned, right? On burglary, what we found was that very consistently, people described burglary type behavior as meriting much lower in seriousness compared to assault type injuries. Not at all at the levels in the current code, which provides a 30-year sentence for any entry into an occupied dwelling with intent to commit any crime, a theft, you name it. The person didn't have to be seen. The person didn't have to actually take anything. 30 years. If armed, you add on another 30 years and a mandatory minimum of 5 if they had a firearm. That's a life sentence, right? For something that did not include any actual harm. So we can talk about that. I don't want to get too distracted, but what I want to emphasize is that the survey results placed burglary type scenarios and ranked them more akin to either something between a simple assault, as Professor Butler said, not at all simple, but a punch, an injury like that, or up to around the level of a felony assault, a low felony crime in some cases. That was a real eye opener, right? Very different, again, not only from what's on the books, but what's happening in court practice, which is tied still to what's on the books. So that was a basis for us to say, hey, we need to take a harder look at this. We did go on. We found that the district is more severe, not only in its authorized numbers, but in what it is giving out for burglary penalties than the vast majority of the US. We looked at other jurisdiction numbers too, but the survey, so burglary is a great example, but on so many others, carjacking as was mentioned, robbery as was mentioned, most importantly, the role of a weapon. Our survey results clearly show that yes, it absolutely matters if a weapon is involved. And what it does is a low level crime, right? What might be a misdemeanor otherwise, when a gun is involved, it jumps up. It becomes more serious. But how much serious, that's the big question, right? Under current law, the while armed enhancement, which the U.S. Attorney's Office is now saying today that they want to maintain the 5-year mandatory minimum. It's 5-year mandatory minimum, but up to 30 on top of whatever it was. That's the while armed enhancement today. That is grossly disproportionate from what the survey results show. Survey results show results matter. Injuries matter. That's it's incredibly terrifying, absolutely, to be in a situation where a gun is involved, and it does raise the potential danger for what could have happened. But when we're looking at results and the seriousness, what voters said is they care much more about the results. Was somebody injured? Were they seriously harmed? Did they, what we would call in current district law an aggravated assault, where there's a serious bodily injury? That's a 10-year offense under current law, comparable here in the RCCA. None of these scenarios, except where somebody experienced something less than a serious bodily injury, even if it was involving a gun, did they think that it deserved something more? It didn't deserve 10 years, let alone 30 years, let alone a mandatory minimum. So we saw, again, a very sharp difference in how voters think about weapons. Yes, very important, deserves and merits more severe penalties. But the question is how much? And the survey results really belie current court practice and what's on the books.
Okay. All right, thank you. I want to see if I can draw in some, and again, I'm kind of focused on some process questions first to our advisory group members themselves. Help me have a little bit of a lens into what's the typical back and forth within the CCRC among those advisory group members when you're working on a revised offense or provision. It sounds like there was lots, I'm going to take everybody at their word. There's lots of really good, honest discussion, lots of good back and forth. And there were moments probably when, again, good, smart, reasonable people had disagreements. But to the advisory group members, can you share a little bit of lens for me into how some of those conversations went, how that back and forth, that push and pull went?
I'll start partly to do a little contrast. So I am partly to blame, as is Pat Riley, for the original idea of not having an independent commission, but putting the mandate in the sentencing commission, because we were meeting all the time. And it seemed like the same people would be involved and would have expertise who were part of the commission. As sort of Richard talked about that, the structure, at least under the previous chair, I'm not on it, the representative on it anymore, from my agency, ran it by a consensus model. And so the commission were sort of like all the appointed people in the institutions, and then the staff would sort of make recommendations to us. So the staff, and as Richard said in the beginning, it was sort of one person, and we would meet as a subcommittee and we would discuss things, but it was sort of by consensus, and the commission members had the power. So if it has to be by consensus, the staff might say, we did all this research, here's a good proposal. And when we couldn't agree, that was sort of the end of it. We had very good conversations and discussions. We also sort of had a very narrow interpretation of the mandate. That was sort of why the independent commission had to be sort of created. And then the structure really got flipped so that the commission then was the staff, Richard Schmeckel and the staff. And then the advisory group was hired. One of the things that I think we sort of certainly commented on substance and had our very sort of different views, a lot sort of influenced about sort of where we are in the system, so you can sort of as institutions. But one of the things that I think we that the institutions brought that I think the commission really benefited from is when we can say, here's how that's going to work, right? That even when we're sort of disagreeing on substance, we can a lot of times sort of say, but here's how that has played out in court. And a lot of us are also sort of served on the Red Book on the jury instruction committee. And so we've had a lot of practice of take a statute, translate it into a jury instruction. How does that work? And so bringing that sort of expertise, I think, was helpful to the commission. But we'd have paper and someone would sort of say, I really didn't understand this, or, I think this. And I think it was for sort of very collegial. And there are times when we would sort of agree, when we'd say, oh, I didn't understand this. I thought it was saying this. And we could then, sort of all get on the same page. And then the staff would take notes, or they would explain, and then they would take it back. And then there would be another draft some months later of a sort of comprehensive draft that we could then comment on again. And I think that's how the process worked. And that the second independent iteration was obviously a much more fruitful structure.
Got it. Okay. Ms. Suttonberg, Ms. Weiser, from your perspectives, can you share as well? And then Professors Brayman and Butler, I wanted to hear from you too.
I can take a stab at it. Thank you, Chairman Allen. I'm sort of the newbie in the group because I wasn't involved from the onset as Mr. Rosenthal was, but I can tell you from the process from OAG's perspective was that Mr. Rosenthal was, incredibly conscientious about evaluating the recommendations and giving his own recommendations to the Attorney General about what he thought was appropriate. And recently, Ms. Gajwani was involved too. And so Mr. Rosenthal and Ms. Gajwani and I would discuss decision-making, right? Like we were getting to the point, are we going to agree with this? What's the Attorney General's position on this? We would compile our own recommendations to the Attorney General on some of the things that we thought were the most significant and important for him to weigh in on. And of course, he is very well acquainted with the entire scope of the reform, but there were particular things that we wanted to make sure that we talked through with him. And we did that, and we got his views. And of course, my testimony today is based upon what the Attorney General's views are. And so where I can articulate his views, I will, if there are more specific questions going forward. But that was OAG's process. And part of our process also was reaching out to nonprofits, public interest groups, others who we thought would be affected by changes in the statute. And we were very conscientious about talking to our partners in the community and the public about some of the changes that the code would create. And so that was our process. And then Mr. Rosenthal and Ms. Gajwani went back to the advisory group and articulated OAG's position, and that was sort of our work process.
Thanks. Ms. Suttonberg, anything you'd like to add there too? Love to hear your experience too.
Sure, thanks. And then I do echo what a lot of my counterparts have said. I think that it was in many ways a very collaborative process. Mr. Schmeckel and staff were always very receptive to further discussions, and we always kind of appreciated the opportunity to meet with them further. I was fortunate enough to have some very intelligent co-advisory group members who really know a lot and have very different perspectives that are really valuable to consider as part of this holistic process. Miss Pat Riley and Renata Cooper, my predecessors, I also want to acknowledge their role in this throughout history, throughout the time that this has taken. They've really had
history, you're right.
I don't mean to make it sound too ancient, but I do want to recognize them, but also my colleagues. This was, I have, as many people here know, I have more of a background in sex offense and domestic violence, and that's kind of where I've spent my time and my more expertise. And so a lot of my colleagues within my office have also really been involved with this process and instrumental in lending feedback on how this would affect murder prosecutions, other types of prosecutions that are really outside of my primary area of expertise. And so I do think that in many ways, this was really a very collaborative process. And so I do kind of appreciate everybody's work that went into it.
Okay, that's helpful. Thanks. And then Mr. Brayman and Mr. Butler, so you're not representing any of the agencies, but you have been a part of this for years. From your perspective, what does that push and pull look like? What do those discussions look like? Kind of getting to decision points. Would welcome your feedback as well. I got to flip a coin, see who goes first, though.
So I'll start. I thought that our work combined the best qualities of an agency receiving expert advice from people who are on all sides of issues and people who've participated in the criminal legal system in many different facets. So we had an extreme amount of expertise on all of the criminal legal issues that we considered. But we also in some ways served as a citizens tribunal. We were made up and heard from many, if not all of the stakeholders on important criminal legal issues in DC. I should note that any person was welcome to attend our meetings during the time that our meetings were in person and also during the time that our meetings were virtual. Any citizen of the District of Columbia, I believe any resident of the United States was welcome to come. And certainly there were many ways that they could share their views with us. There were, as others have said, widespread, or not widespread, but occasional disagreements, strong disagreements on some issues. I do think that Don and I, as the geeky law professors, were especially invested in the model penal code, which is a proposed code passed by the American Law Institute in the early 1960s. Virtually every jurisdiction other than DC has updated their criminal code based on the model penal code. We in the district never have done that. The model penal code is widely respected by legal scholars, and I appreciate the openness of all of my fellow advisory board meetings to learning about the important scholarly developments that informed our process.
Thanks. And Professor Brayman?
Yeah, I would say, just to give you a flavor of the type of information and the process that we went through, the staff would present very detailed reviews of both the statutory the statutory provisions we were looking at, all the case law in the district that dealt with that, potential ambiguities, because there's always some sort of problem, even with the case law, trying to interpret these really ancient statutes, how other jurisdictions had resolved these problems, where they had caused problems in other jurisdictions, and then additionally also looking at expert opinion in the sense of consulting the model penal code and other writings about the problems that we were discussing in every single case. And I think that the disagreements, really the vast majority of what we read and then considered and approved had almost no disagreement. It was so very straightforward, reasonable, and appropriate. The disagreements, of course, are more memorable. And so I think there was almost always at least one tiny thing that people, or one big thing that people disagreed with in a very, very substantial set of clarifications and proportionality adjustment and rationalization of the criminal code. And so I think it's appropriate that we be discussing some of those disagreements, but I really want to note that wherever there was disagreement, a similar process of doing additional research through all of those sources and then discussing with stakeholders happened. And we, many of us were in contact with lots of community groups and community members discussing the problems with the code and potential solutions. And so I think I've seen the records of these types of reforms and reform efforts around the country elsewhere. And I don't think anyone has done as extensive, open, or good a job as the district has. And in fact, I think you could be proud that in addition to the looking at the model penal code, Director Schmeckel and his staff and all the members actually improved on it in several key respects. In places where the model penal code had run into a little bit of trouble or was unclear, it's a remarkable achievement. And so I think that it's going to be a model for many other jurisdictions when, I'm going to be very optimistic, when it is passed.
Thanks, I appreciate that. And thanks to all of you for helping share that. Deputy Mayor Gelder, I was going to pull you in for a little bit here on some process. How that I'm going to do this, I'm going to start with a couple of things I agree with you on, and maybe something I disagree with you on. So let's start with where we agree. A couple of, in some of the earlier hearings, I talked about this a good bit of asking, for example, with the courts or asking other places, assuming that at some point this is going to pass, some version of it's going to pass the council and it goes to be implemented. what is a reasonable amount of time that we would need to essentially delay an effective date to be able to make sure that our criminal justice system is able to then effectuate it? I think you said that, we talked to the courts, for example, about how long that would take. We talked about updating the Red Book and how long that would take. We talked about, having the different attorneys be up to speed, like a lot of work, right? If I'm focusing on, in your testimony, you talked about educating our MPD members, for example. I think you said you thought it would take about 80 hours or so of retraining per officer. I don't disagree with you that there's going to have to be that level, there's a level of retraining. I don't know if is it 70, is it 90, is it 80? I don't know that. But from your perspective, how long do you think it would take to develop the curriculum, do the administration of that retraining to officers to then have that take effect? From your perspective, what do you think that would actually look like from a timing perspective?
Sure. And I would love to give you, like, in 3 months we could be done, but I just can't do that here at this time. The agencies are looking at this. We've all, myself included, I had to read it. I'm not a lawyer, so I had to read it 4 times, the 300 pages, just to really get a good feel for all the things that it's calling for. So I can't give you an honest answer right now, Mr. Chairman. Suffice to say, though, that I will. And I do think hearing from those agencies of what the training, and then maybe there's things they need some clarity on in here as well, because as we move forward, there's certain things that we could move forward with training on, and we could get a determination on how long it would take. But in the end, what gets passed, that may, influence one way or another of how long something would be. But we can give you a good estimate on that.
Okay.
I could do that by the first week of the new year.
Okay. I think that would be helpful to kind of just understand. I can't sit here and tell you 80 hours is exactly what it would take. I don't know that. But I think we should be able to kind of say, okay, ballpark, this is what it would take to do 80 hours retraining. It could be 80 hours retraining on something completely different. What does that typically look like to be able to get through the workforce?
That's right.
You'd also talked, one of the concerns I talked about with some other witnesses in a previous hearing was something you brought up as well, and that is the use of the term complainant and how that could create confusion around whether a victim of a crime qualifies for rights under the Victims' Bill of Rights, for example. From your perspective, is this a substantive issue, or is it an issue around a conforming amendment? Here's what I mean. We could always add language to ensure that regardless of whether the RCCA itself uses the term victim or complainant, the understanding would be that they are synonymous for the purposes of receiving crime victims compensation, qualifying for advocacy services under SAVRA, or other services dedicated toward victims and survivors of crime. We had a lengthy discussion in a previous hearing about the intent around the neutrality of a term complainant. And then, of course, how does that work from the perspective of identification from a victim or survivor? How does that work from a jury instructions? How does that work with all this? So from your perspective, is that a substantive issue, or is it more of a, hey, if this is the word choice that ends up being in here, we're gonna have to have some conforming amendments to make sure these other services for victims and survivors are in alignment?
I think it's mostly the latter. And, as I said, and made the recommendation in my testimony, Michelle Garcia, who has been doing this for many years in the city and does a great job with it, can be the input voice for us on what we need to do. And she's actually going to be submitting some testimony or letter to your office to kind of lay out what that would look like and what we would need to do. So it's just real clear from her on that side of it. So that as we work that technical piece, as you mentioned, to make sure that we don't unintentionally count somebody out of a benefit that they would get. She's going to provide all of that to you. She's already working on that. So I think that answers that piece. I would say, though, that for me, as I read through it, and then listen to the testimony here, we are extremely offender focused as we went through and did this work. And now I want to be very clear. I think the CCRC did a phenomenal job with a very hard task over many years and has come out with some very, very important things that we have to get done. But it is very much offender focused. And my concern would be there are other two groups of people, even in the restorative justice spaces that we are here in the city. We still have to take into account the victims, which we are now not going to call victims anymore, and the community. in which crimes have happened. And even in restorative justice, there's accountability to those two groups from the offender. So when I say that, for the most part, it is making sure that our victims can still be taken care of through all the services that are being provided, whether for the federal government or local government. That is the major piece of it. But underneath that, for me, as I read through this, how does it best forward or benefit public safety if we leave the other two groups out that are mostly affected by this legislation that we're passing? So there's three equal.
I would definitely disagree with the assumption of saying that they're left out, but let me turn to the panel, to our CCRC panel. Why would it be that when you're writing a criminal code revision related to the guilt?
Actually, Mr. Chairman, that's not actually.
No, Mr. Gelder, let me ask, why would it be that language would focus on the offender?
At this point here, where we take this forward is what I'm saying, where we take this forward from here in adopting.
No, I want to follow, Deputy Mayor, I want to follow that thread. Let me hear from some of the other panelists around that.
So I find this a really interesting discussion. I was actually about to do a quick Westlaw search because I don't think we use the term victim in our current code. I mean, our current code says things like don't do murder, right? And it doesn't even define what murder is. If you do manslaughter, go to prison. Like that's what our current code said. It doesn't even have the word complainant in it, but it certainly doesn't have the word victim throughout it. And I also think, I mean, you know, as a person who went to, I think, all of the meetings over basically the 16 years that it met, I can tell you that in our conversations, and I think Deputy Mayor Geldart may be at a bit of a disadvantage here, as he didn't attend the meetings, nor did a representative from the mayor attend many years of meetings. But mostly talking about what an offense should look like or a penalty should look like, we were talking about effect on the community or effect on a particular person, a victim of a crime. But to answer sort of more, I think the question I heard you ask, Chairman Allen, what Deputy Mayor Geldart were sort of saying, no, here's what I'm saying. What's interesting about this, it strikes me, is to think like how you go talk to the community about who's a victim and who's an offender. Like, what are the assumptions about who answers those questions? I do think that part of our problem is we build a system with a lot of input from people who could never imagine themselves or anyone they love being on the other side, having to sit next to me or my colleagues at our table. And therefore we end up with draconian sentences and all of this until you end up, like Professor Butler talked about, charged, and you're like, oh wait, what? I don't get a jury trial? Because no one can ever imagine themselves sitting next to us unless you actually come from my community. But,
actually, go ahead, finish, and then I want to pull in Mr. Butler.
Okay, but all that to say, I do think, and there were lots of opportunities for the public to be involved in this. I do think a lot of this is in the weeds, and to sort of pull the public on, like, so seriously, what mental state for trespass, right? Like, some of this is in the weeds and really is going to be just sort of like listening to experts and figuring out how a comprehensive code should fit together. But I do think it's really hard and in some ways almost offensive to kind of talk about, let's go talk to victims, as if in some before land we know who a victim is and who's not a potential victim, and somehow let's go talk to some set of offenders in some, again, beforehand perspective way. So I think that's just an odd framing.
Well, let me pull in Mr. Butler if I can, because, all right, Mr. Butler, so under one lens, when you were arrested, sharing the example that you did, you were the offender for that moment until you went through the jury trial. Help me understand too, as you sit here now in this position of helping craft the code revision, would welcome your thoughts on this too. Kind of, you've got a lot of lenses to help us with.
Yeah, so I think semantics are important. So whether we call people victims or survivors matters. It also matters whether we call people offenders. And the reality is, until someone has been convicted of a crime, they are not an offender. In the eyes of the law, they are presumed to be innocent. I want to call the name of my friend Lanice Herbert, who teaches now at Howard University Law School, but served while I did as a United States attorney, as an assistant United States attorney in the District of Columbia. And she had this phrase, any given Sunday. And what she meant by that was, on any given Sunday, the person who she was prosecuting for a crime might the next day be a victim, and the day after that be a witness. So she also didn't see the same bright lines that the deputy mayor seems to draw between different constituents in our criminal legal system. And along those lines, when you imagine a typical victim, you should imagine a young Black man. In the District of Columbia, he is the person who is most likely to be harmed by a criminal act. And that might not be who you think of. And if you shift your understanding to the fact that young Black men especially need public safety, that helps us understand that not every victim, not every survivor thinks that the appropriate response is to lock the guy up and throw him under the prison. And that I appreciate the deputy mayor's references to restorative justice. One of the things we've learned from restorative justice is that survivors, people who've been harmed, they're not focused on punishing the actor. What they're focused on is making sure that he doesn't do that again, or she doesn't do that again, and making sure that to the extent that they can be compensated, that they are compensated. And so I appreciate, again, the deputy mayor's support for or citation to restorative justice, because I think that what we'll find is that many of the people who survived harm in the District of Columbia enthusiastically support our proposals, because they make our criminal legal system more legitimate. When it's more legitimate, more citizens buy into it, more citizens will avail themselves of the services of the MPD and the U.S. Attorney's Office. So restorative justice and this reform project are hardly the opposite of public safety. They're entirely consistent with advancing public safety in a way that makes all citizens safer.
Yeah, I want to give Deputy Mayor Geldart a chance to respond to, and real fast before I do that, I think just some incredibly important points. One is that, too often there's this kind of false dichotomy of, victim and survivor and offender, when we realize that oftentimes someone who commits harm has also been the victim of harm. But it's important that throughout this process, I think this project is trying very much to recognize that that there is harm that is done, and then try to think about what is the process by which we have a fair and just due process to have accountability for that harm. I don't view this project at all as saying that there is no harm. It's about trying to think through what is the way in which we are revising our code to address that harm. I think that through. Deputy Geldart, since you got called out a couple of times, let me give you a chance to respond as well.
Sure. No, and I first of all, I agree with Mr. Butler 100% in what he was saying, and I agree with you, council member, as well. If I could be very, very clear, what I'm saying here is, from this point where we are, what the CCRC has done in their process in bringing this to the point of where it is yeoman's work. I mean, hands down, great work with all the folks that showed up, to include the folks from my office that were there in all of those meetings as well. I wasn't a deputy mayor of public safety until last January, but the office has existed and the folks have been there. So my point in bringing up what I did is right along the lines of my testimony, which is, at this point where we are with what we have, I think we need to get the full balance view from the community. And in that community are all of the folks. You're going to have returning citizens. You're going to have folks that are there that have at times been a victim of a crime, may have been, on any given Sunday, any one of the three that Mr. Butler has said. And that's the folks that we want to make sure hear about this. I understand there is a lot of dense material within here, but I would not want to say that, the community is not going to get it. So we shouldn't, I think we need to give the opportunity for our communities at this point where you and I are, Mr. Chairman. We have received this work now. We've read through it. It's great work. Our community needs to have the input on it now. We need to make sure that we're doing our job and getting it out there so that as we change our criminal code, we can get exactly what Mr. Butler said, which is a community that buys into it, believes in it, and serves it well.
Well, let me go into that a little bit. So I acknowledge, Deputy Mayor Geldart, your tenure as Deputy Mayor overlapped only briefly the CCRC. And so by no means have you been the Deputy Mayor for Public Safety and Justice for years and years and years. But from an office perspective, how often did the Deputy Mayor's office attend the 51 meetings?
They were at every meeting.
I have from the CCRC that the Deputy Mayor's office was present for 10 of the 51.
I have my staff person who was at those meetings sitting in this room.
Mr. Schmeckel, I don't mean to make you be the referee here, but since there seems to be a disagreement and you like to play the middleman.
Yeah, I can tell you that since the beginning, the designee from the deputy mayor preceding Deputy Mayor Geldart was the then chief of staff, Helder Gill. We have in our minutes clearly reflected that he attended one meeting over the course of the 4.5 years. Beginning in last, I think, June of 2020, another staff member from the agency joined to listen in. I don't need to pull his name out because he wasn't the designee. I believe he was listening in for about 7 meetings. But again, I don't know how much behind the scenes may have been going on. I think in all the agencies, they've been working tremendously hard on many issues, right? So all I can report is who was at the meetings, who's reflected in the record. Those meetings, all the minutes, everything has been recorded. It's online, it's posted. This is a matter of public record. These were all open meetings under the Open Meetings Act. So I suspect it's just a mistake that's in communication happened somewhere along the line. But in terms of participation, look, agencies have done different things. The representatives, Paul Butler and Don Brayman, representing a broader swath of the community as well as academics. All of them have had conversations in different ways at different times about different issues. I understand this is a big deal and we got to get it right in terms of making sure people are informed and have a say. And, this is the 3rd hearing after years of process that's been fully open. Where the line is drawn as to say delay is an impediment and an obstacle to justice versus some delay is necessary for further discussion. That's that's your ballpark, but I can relate that process. And I could go into more detail about the levels of participation, but the members themselves can kind of say who was at the table, to what extent. There's a written record.
Can I be a little bit of a
shows
defense
things.
attorney here, please? And
Well,
partly having.
I think we're going down a road that's not.
No. I do want to say this because I just
At
want to be fair,
So,
and partly
I
because
mean-
I started with this. I do want to say that there was also I at least have forgotten the sort of structural change, right? Which is that the Attorney General used to be a part of the executive and sort of the mayor's staff. So in the original iteration of the bill, right, the sort of like the OAG representative on the Sentencing Commission who then worked on code reform would have been representing the mayor. And the issue is, right, we're sort of like there ended up, you know, maybe we lost the voice of the mayor is when the Attorney General became independent, and then that representative was still coming, but then representing the elected Attorney General. So I think partly as the person who sort of started the sort of like, where was the mayor's office? That was unfair in the sort of sweep in which I said that. So I do want to sort of correct the record on that, because it is not never when structurally there was a different voice.
I think it's a fair point, obviously, from when the Attorney General was not independent. I think the issue is once we separated in the two non-voting appointed members were the Committee on Judiciary and the Deputy Mayor. I also want to note it predates Deputy Mayor Geldart taking over his role as well. But when we talk about where we're going and that different type of engagement, I do think it is relevant. Deputy Mayor, I did want to, you know, I do believe that it's appropriate to push back on this concept of public. And I think as you've heard others talk about how public this has been, I can't think of a piece of legislation that's had 3 public hearings. If I can find one, I will. We've talked about the fact that this is you know, I think in your testimony, you called this rushed, which I would certainly take issue with after 15 years of work. And we've already said that this is going to consume work through 2022 before the council ever has something up in front of it. So I would not categorize it that way. But I mean, we're in the public discussion right now. It's happening literally right now. And so I think that if the standard is, and are you suggesting the standard should be that we should take any piece of legislation? I mean, I can think about our ghost gun legislation, bump stocks, extended magazine clips. We worked very collaboratively with the executive, brought stakeholders in, put forward legislation, held a hearing on it, then had the people that were elected by the public vote on it. Should we have gone and held board meetings on each piece of legislation? Like, where do I draw the line between what you're saying would be what you would suggest for something for this piece of legislation versus not another piece of legislation?
So, Councilmember, what I would say is I don't believe, as a matter of fact, I don't think I was saying that it's been rushed. I don't want to rush, is what I'm saying. And I also said in there, I also don't want it to take 9 years, but I do think it is very important that in instances like this, and the other example that I actually gave in my testimony, where when you're doing large reform like this, that we give the opportunity for our communities this will most affect to be able to have a voice. We've done it before with the council. Where the council draws a line in that, I can tell you personally where I think in something this large, yes, I do believe that we need to go beyond just having hearings and having those that would attend hearings. You know, and we're still in the virtual world of doing hearings. I think in a large swath, as we're looking at this, the great work that's been done by the CCRC, all of this has been compiled. It deserves more than, I think the CCRC did as good as they possibly could have in doing public outreach for their piece of what they did. They've reached out to about 2,000 folks of our 705,000 residents. I think though, before a bill like this is passed and implemented, we do need to have more than 0.002% of the population weigh in on what they believe we have here and give recommendation. You know, it's a public discourse on our criminal code reform, which hasn't been done since 1901. You know, we need to get the input from the executive agencies, which we're compiling and giving to you, and in our community, which is most important because that's who's going to affect the most.
The CCRC had 51 meetings, or would welcome getting agency feedback. Did the Deputy Mayor's office or any agency submit comments to CCRC over the last 15 years?
Council member, we could keep playing that record. But honestly, right now, we have a bill, we have a process that the CCRC has put forward. The implementation pieces of this is what we talked about, what it's going to take to implement it with the agencies. That's what I'm talking about. The substantive pieces of it, the community has, we cannot say that we have gotten this out to the full community. Have we made opportunity for the community to be a part of it? Sure. But when we're talking about something this large, I think just like we did when we changed, when we had the zoning changes, we went out there and made sure we went to multiple community meetings, overly went out and engaged with the community to get their input. I don't understand why that would be different here or why that would be less desirable as we're changing the criminal code, which will create changes in our public safety ecosystem throughout that will directly affect the communities. I just don't understand why that's a problem.
I think for the people and public that participated over the last 15 years and 3 hearings, I don't think would say that there hasn't been an effort to engage the public throughout.
I didn't say that either.
We spent some time getting into some of the specifics items that we talked about today, but it feels like a very tricky road to decide which bills we like and we don't, and which ones need to go through what type of process, if that's
Okay.
So let's go see if we can drill down on some of the specific items here. I heard a lot of good discussion around jury demandability. If I can spend a little time on that. Partly, again, to make sure we lay out the record for this. What are our current constitutional requirements for the right to a jury trial? And then how does the district compare to that? We talked about in different jurisdictions. I think Mr. Butler, you talked about, if you were accused of a crime in Virginia or Maryland, there are crimes in which you would be able to go before a jury of your peers, but in the district you wouldn't. Can someone share a very clean description of what we think our constitutional requirement for a right to jury trial is, and then how the district compares to that? Mr. Butler, do you want to go?
There are constitutional requirements for what a jury trial, when a jury trial is required, and the district does meet those. There are sometimes disputes over what that means, and those are litigated by the parties, but they meet all of the constitutional requirements for a jury trial.
And kind of in layman's term, can you just help say what that constitutional requirement is?
I don't have that in front of me right now. I do know that the 180 days, I can look it up.
I think
So
Mr. Smith
in
was trying to get there too.
what the Supreme Court has said is that if the punishment for a crime exceeds 6 months in prison, then one has a right to a trial by a jury. But of course, a legislative body can always give citizens more rights than the Constitution does. The Constitution is a basement rather than a ceiling.
Mhm.
And the reality is that in 40 other states, people have greater access to jury trials than they do in the District of Columbia, including in our neighboring jurisdictions of Maryland and Virginia. Even in DC, there are weird anomalies now. So former Chief Judge Washington pointed out that now people who are charged with misdemeanors that may bring immigration consequences have greater rights in the District of Columbia to a jury trial than any other citizen. The Court of Appeals for the District of Columbia decided a case in which it said that if you are charged with a misdemeanor that doesn't carry a right to a jury trial, which is the truth about most misdemeanors in the District of Columbia, but if there could be adverse immigration consequences under the law in DC, you now have a right to a jury trial. And so someone who is not a citizen of the United States, charged with a crime, let's say simple assault, where there could be consequences that might include deportation, would have the right to a trial by a jury. Someone who grew up in Anacostia, charged with exactly the same crime, would not have a constitutional right to a trial by jury. And I think that what Chief Judge Washington suggested is exactly right. We don't want to level down. We don't want to say that because most people in DC don't get a right to a jury trial for misdemeanors, that people who face immigration consequences should not. We want to level up. We want to make sure that people in DC who were born here, who've lived here all of their lives, who are citizens of this country, have the same rights to a jury trial as non-citizens. And again, what Chief Judge Washington pointed out is how close the relationship is between the right to a jury trial and democracy. And I think that it's very difficult for the mayor or a member of the city council to champion home rule and the idea that the District of Columbia should have the same rights as every other state, when at the same time, some members of the council are not enthusiastically supporting repealing the misdemeanor streamlining act.
Yeah. And Mr. Butler, can you share also just a little how the district ended up with, like, we had more expanded jury trials previously. How did we end up? Was it it's a court efficiency issue? It was the docket was too heavy issue. What were some of the reasons about why the district moved to the current 180-day threshold?
The U.S. Attorney's Office didn't like how Black jurors were responding to some of its criminal cases. That's the reality. Now, what we've heard and what they've said is that it was an efficiency issue, that this was a time when there was more crime in the District of Columbia than there is now. And the concern was that misdemeanor trials are somehow inefficient. In fact, the Bill of Rights is inefficient. The requirement of a right to counsel is inefficient. It's expensive. What I believe is that if 40 states can afford the quality of a criminal legal system, including the right to a jury trial, then the District of Columbia can afford that too. And again, quoting the Chief Justice, the Chief Judge, he says that we should not let the constitutional right to a fair trial be overruled by money, by efficiency. And finally, I know I'm talking for a long time, but it's just so important also to understand that respecting the concerns about efficiency and public safety, the Code Revision Act allows a very gradual 3-year process before the right to a jury trial is fully restored. So during that time, there'll be plenty of opportunity for all stakeholders to see how it's working, whether something needs to be changed or done better. But at the end of the day, this is about democracy. This is about giving DC residents the same respect and the same rights that citizens in almost every other state have.
I want to make sure I give Ms. Suttenberg a chance, because I think anytime somebody speaks for a different agency's motives, I want to make sure I give them a chance.
And just for the record, it was a different U.S. Attorney's Office in a very different time.
I hear that. I have a hunch that Ms. Suttenberg wants to make sure she can speak for USAO as well, though. So let me let her have a chance.
Thank you, Chairman Allen. I did just want to note, I did spend a lot of time in my previous written comments before the CCRC looking through the legislative histories on those previous reports. And I spent a lot of time citing actually to the testimony of previous chief judges on this issue. This is not just a U.S. Attorney's Office issue. This is an issue for the courts as well, to be clear. We are in the courts. We staff courtrooms as needed. But this is an issue for the courts first and foremost. Previous chief judges have weighed in on this in writing, while not opining on substantive criminal law as is appropriate. And we, in my testimony today, I just encourage the council to involve Superior Court in this decision. It can't be legislated in a vacuum. There are important considerations that need to be taken into account, how this would impact criminal cases, how this would impact non-criminal cases. And I think that that needs to be a holistic assessment of what this will look like in real life and how it will play.
Yeah, no, that very much appreciate that. We definitely we do and continue to want to hear from the courts. And again, as we talk about some of the different implementation issues, no matter what decision ultimately gets made, we have that around that. I mean, it's, I guess in the mid 2000s, we had about 200 to 300 more jury trials than we did pre-COVID in 2018, 2019. But I don't dismiss as well, though, there obviously are practical capacity questions that have to be answered, but I also don't think those should be the limitations of what is the decision we make. Mr. Schmeckel, you look like you're trying to jump in.
Sure. Yeah. Again, a lot of different perspectives on these things. I want to put in some numbers to kind of inform this a bit regarding the capacity issue, which is wholly separate from the primary argument, which was articulated by Professor Butler and others. On the capacity issue, it's definitely something that needs to get looked at. And we have done some research, but much as with referring to victims, representation, we heard from victims organizations at the last hearing. And I can assure you that in this case, with regard to the jury demandability, the chief judge of the Superior Court, both the prior chief judge and this one, is aware of the recommendations. I don't know what they are planning to do, if they will be submitting written testimony. That is obviously their concern. What I can say is that since the early 1990s, when the, again, at least ostensible on the record reason for changing the level of jury demandability to denying the right to a jury in more cases, since that happened in the 90s, that was the peak of the crime wave then. Crime rates were triple, according to FBI data, what they are today, triple, just massively different. Cases were going before the court massively different. In one of the U.S. Attorney Office's comments in our back and forth in developing the recommendations, they actually quoted some testimony back from 1992 when this was all in consideration from former Superior Court Chief Judge Ugast, who said in 1992, for misdemeanors alone, there were 25,000 cases. Okay, now that is massively different than our entire caseload in recent years, which is down in the range of 12,000, 10, 12,000. So we're talking about a caseload, total caseload, felony and misdemeanor right now, less than half of what it was in those early 90s when they thought there was a crisis and they needed to change allocation. Since the 1990s, so we've had crime rates drop to a third of what they were. We've had cases drop to somewhere around half of what they were. We have had more judges added. The same number of judges has been there, and a few more have been added on. Now, how they're distributed throughout the court, which docket they're on, right? That's up to the chief judge to try to, do the best they can. And that's going to evolve. But in terms of capacity, look, there are always capacity issues, right? Criminal justice, again, it is inefficient to provide process, and yet we have to do that. There are resources there. We're in a very different place than we were in the early 90s. And, given all of that, obviously if the court has concerns, they should raise them, but we have designed this provision in the CCRC's bill to give a phase-in time that could be, looked at more, but to give the courts opportunity to come out of this current difficult time. Right now, there really is some difficulty because of COVID and because of judicial vacancies, right? So some period of time before, making this change makes sense, but it fundamentally makes sense. It is a fundamental good, and their resources are there, arguably, to do it now. As to the judicial resources I've spoken to, the U.S. Attorney's Office can speak to its resources. How has its number of attorneys diminished since the 90s? How much more would it take? But I want to emphasize that this is a dynamic thing, right? Charges, what charges to bring, and whether to proceed with a plea deal, which is the mainstay of the court process. All this talk about jury demandability is in some ways completely misrepresentative of what happens in the courts. Well over 90% of cases are disposed of through pleas. The criminal justice system is a plea system, right? The idea of a trial at all, let alone a jury trial, is on the fringe. It's an important, critical thing because it can handle some of the most difficult instances where a person needs to have the perspective of the community, but it is on the fringe. Almost everything is through pleas, and that is a process and control of the U.S. Attorney's Office. How they react and change their charging practices or don't, according to under the new laws, is going to be, I dare say, they don't know themselves, right? Like this is a big set of changes, and it's going to change charging, and that's going to influence case flow. So I don't think we can say how many cases may increase for jury trials. It's completely speculative at this point. It is reasonable to say they will increase, but how much we don't know, and how much the court resources are there. Again, laid out some facts, and I'll let the U.S. Attorney's Office, speak to its own resources.
Well, if I can, before you, I want to bring in Professors Brayman and Butler, because I'm not going to ignore the fact that, sure, there are resource issues. There are, considerations around how you bring the juries in, how do you schedule the docket, right? I don't think anybody's pretending that those things aren't things you have to plan for, consider for, manage for, finance for. But that shouldn't be the basis of which principle we choose to follow, I think. And Professor Brayman and Professor Butler, I'd love to get your thoughts on that. I see Ms. Weaver.
That's exactly right. I work through an organization, the Justice Innovation Lab, with states and jurisdictions that have to deal with this problem, prosecutors' offices, courts, police departments, and everyone around the country is facing a backlog due to COVID, but also a backlog due to lots of things. But in no jurisdiction that I'm aware of are they considering dispensing with their current rights to jury trial in order to deal with that backlog. And I don't think that should be on the table here either.
Thanks.
And I think it's vital to think about racial justice and to understand that it's no coincidence in the jurisdiction that has the highest proportion of African-American jurors, those jurors have the fewest rights, or people who are accused have the fewest rights to access jury trials.
Thanks. Ms. Weezer?
Thank you. A couple things, such an important discussion, but I think, from the perspective of the Office of the Attorney General, we begin with the premise that change is hard, right? This is a big, big systemic change, and it's going to be significant when it happens. But we cannot and should not deprive people of fundamental rights. And we can fix this, right? We did it in 1994 with the Misdemeanor Streamlining Act, but we can fix it. And there are people here that are on this call that I know very well that practiced in Superior Court before the Misdemeanor Streamlining Act, and we got stuff done. We tried cases, we pled cases, we did a lot of things to manage the fact that we were dealing with very high dockets in the Superior Court. We can make this change, give people their fundamental right to a trial of their peers, give it back to them. At this moment in our city, where people in our city are demanding reform in our criminal justice system, right? We've heard the clarion call, if you will, about police reform. We've heard that we need to right size what's happening in our city, and we need to treat our citizens better. This is a beautiful way for us to achieve that by telling folks in the city, yes, you have a right to a jury by your peers. You have a right to a check on this government's incredible power to put you in jail, you have a right to challenge it so that all of those collateral consequences of being in jail might not happen because you get a chance to have a trial by your peers. So those are the things that we need to focus on. And we need to also remember, as Mr. Schmeckel said, crime is way down. our misdemeanor cases are way down. I mean, this is going to have a huge impact on the Office of the Attorney General because our adult cases are all misdemeanor cases. And so we know very well how that is going to affect our practice here at OAG. But the truth is that we also have off-ramps that we've been using really successfully to weed out minor cases like misdemeanors, right? One of the lessons that we've learned from the pandemic is that we can actually not charge as many low-level misdemeanors, and the folks that are not charged with those low-level misdemeanors are not recidivating. We know that people who are given citation release for low-level misdemeanors are not recidivating at the rate that they might have otherwise if they had been incarcerated and lost their job, lost their family, lost their place to live. And so these are the reasons why, the fundamental reasons why we need to look at this very carefully, and we need to roll out a plan to give folks their right to a jury trial for misdemeanors.
Thanks. Ms. Sutton.
Thank you. Mr. Schmeckel noted that the number of cases in Superior Court has been declining, recognizing that I don't have any insights into broader historical trends, at least in recent years, the last 5 years or so. That's because we're papering less cases. We're looking at cases with an eye toward reform and looking at our papering decisions, what is in the best interest of the public. 2019 and 2020, we papered about 52% of the cases that came to us. So we're really looking very carefully at what cases should be going forward and what cases shouldn't. I agree with what Ms. Weiser said. I think this is part of a broader conversation about off-ramps. We've been expanding our diversion opportunities to both different types of offenses and different types of people who commit offenses with longer criminal histories, and really looking at what we can do to expand this. We're looking to restorative justice. We are looking for off-ramps throughout the system, and ways that people can not be involved in the system, have a conviction if that's the appropriate disposition for them. We've also, even before it gets to the court system, we've been working with the Department of Behavioral Health and with other partners to talk about ways that we can match people to get their mental health needs so that they never get arrested at all. We really support a lot of these things. This jury conversation, demandability conversation, is a piece of that, but I do want to recognize that even when we are doing all of these changes, Superior Court still has some capacity constraints that we need to look to. This affects not just misdemeanor crimes, but also violent crimes, because there's only a set amount of judges and jurors who are available. It impacts not just criminal cases, but also cases on other dockets, because there's only so many judges available. Once again, I do think that this is something that Superior Court is best poised to discuss, and to discuss in terms of how this will impact criminal cases, non-criminal cases, and their operations overall.
I appreciate that, Ms. Suttenberg. I guess one of the things I'm trying to make sure I understand from your perspective then is, and again, I actually don't dismiss at all the fact that there is a practical consideration, right? And I would want to hear from the Superior Court and talk with them about what impacts they think that would mean in terms of courtroom space. Will jury trials increase or not? But assume that they are. What are the impacts? Practical considerations. Is that from USAO's perspective of highlighting this as a concern, is that the area of concern from USAO, is the practical considerations of how do you operationalize that? Or is there something about making more offenses jury demandable from the principle of it that USAO is concerned with? I'm just trying to make sure I can kind of pull that thread a little more.
The primary impact is a practical one, and how this will impact all of our cases.
Okay. All right. Thank you. All right, I feel like we probably went through most of that. Mr. Schmeckel, anything you wanted to add? And you talked about essentially the phasing, I think is the way you phrased it. Would I be correct in interpreting your intent around phasing, or the proposal is to address that practical impact of adding more jury trials if that were to comes to pass?
Right. So that was the goal, was to give some extra time for training in-house, right? Again, I don't know if it's been spelled out in this hearing, right? But the fundamental notion of the bill is that there would be some delay for all aspects of the bill from the time of its passage to its effective date that might exceed what would normally occur with any other criminal justice bill. In other words, there would be some amount of delay in terms of going into effect for a change to the burglary statute or anything else, because there may need to be some additional consideration for the courts changing their computer systems, some of these practical considerations. So given that, the thought was, well, even beyond that delay, some additional consideration for jury demandability and the expansion of jury demandability is reasonable. So we tried to do that. Now, which offenses are in there, which aren't, I think are certainly, something that could be looked at further. I haven't heard that level of specificity from any of the responses that we've received. And in general, I think the emphasis is on getting to a place where the district follows what most of the country already has, in terms of jury demandability. And from a code revision perspective, maybe I could add one more thing, which is, because this was raised in some of the testimony from some of the others, is that somehow take this issue of jury demandability is severable or different and not intertwined with the substantive criminal code. And I want to just briefly say that I think that is absolutely wrong. And I think the record clearly demonstrates this, because if you look at the record of how the NERAC's changes to assault on a police officer were largely ignored in practice in terms of charging. I'll say more about that. And also how charging happens around some offenses like threats, the difference between attempted threats and completed threats. What you see in these instances, assault on a police officer, whether it's a jury demandable version or a simple assault that is non-jury demandable, but 2 days shorter. And in threats, whether the charge that is brought is a full threats charge, which is jury demandable 6 months, or whether they choose to charge the attempted threats, which is non-jury demandable and 180 days, 2 days less. We have seen and it makes total sense. I don't mean to sound wrong about this, because these are the tools in the code, right? The prosecutors are going to choose what is most efficient and in their minds does justice, right? But what we have seen is a selection to charge in order to avoid juries and jury demandability. And I could say more and give some statistics on that, but those examples are definitely there. And despite what the council said, for instance, on assault on police officer, we see a clear shift in charging from assault on police officer when the council mandated that it be jury demandable. Those charges were largely displaced and appear to have been brought as simple assault charges instead. So I want to point out, this is a critical aspect of how charging works, of how the substantive law works. It's an example of where procedure is actually distorting the nature of the crime, that we're seeing choices to charge lower level misdemeanors that are non-jury demandable. Things like including misdemeanor sex abuse, which I've heard reference. These are important charges, and but for the fact that they are now 180 days, I think you would see and the RCC proposes higher penalties down the road, and that what we've seen for years is, this is from the Public Defender Service, at times asking for higher penalties in some instances that are jury demandable, recognizing that might be fair, and the U.S. Attorney's Office at times advocating for lower penalties that aren't jury demandable in other cases. Now, look, we have incredibly smart, gifted advocates on both ends of the spectrum. They're working and trying to make sure the procedure works to the ends they want. But my goal is to put those aside, put that gamesmanship that does occur now around the question of jury demandability aside. Let's provide the fundamental right to everybody. There are resources to do it, although it may take some doing to make sure this gets implemented correctly. And it's right to hear those concerns and address them. But this can be done, and it will end up making the substantive criminal law, the charges that are brought, the focus, right? what is the appropriate charge, not based on whether there's a jury that comes along with it or not, but what is the charge, the description of the elements, and the penalty that is most fitting. Let that be what dictates the choice on charging.
Yeah. Mr. Schmidt, I really appreciate you walking us through the NEAR Act and the APO example, because that to me is a direct line example of data helping inform and seeing when you change the structure in the process, what happens. And I think to Professor Butler's comments around the fact that when you're talking about the structure of a just system, which is incredibly unjust currently and has, as we've talked about, and I don't think anyone argues, has incredible disparity and racial inequity within our system, that it is the process and the procedure that there's an opportunity in front of us. And we're not going to get it all right, probably, and we're probably not all going to agree with whatever the final product is, but we have an opportunity in front of us to make substantial change to then be able to focus in on when harm is done, what are the appropriate and the right charges, and what are the appropriate and right measures of accountability for harm that is done. And I think I think that example that you gave is one that really helps show what the impact on the process and structure is, and opportunities of when we can make change on it. I want to start diving into a few of the substantive offenses, if I can, for a moment. And I want to start with homicide. Professor Brayman, I might pull you in a little bit on this one. And I guess if I can first, let's make a general point first. You spent a lot of your testimony explaining why certain fact patterns should not constitute a first-degree murder. Just to make sure it's clear for the record. Does that mean that those fact patterns would go unpunished under the RCCA?
No, absolutely not. And this is why the jurisdictions that have dispensed with felony murder doctrine have not seen fit to reinstate it. Generally speaking, all that it requires is the charging of alternative felonies, including potentially homicide charges that are equally appropriate, or in many cases more appropriate than a first-degree murder charge.
Okay. Could you, again, also for the record, kind of help briefly explain the legal, and I'd even say corresponding moral, difference between a first and a second-degree murder?
Yeah, so it's an arbitrary distinction that was made in the United States historically, and it's meant to distinguish the most heinous types of murders from those that don't meet that description, right? So second-degree murder is really just defined as not the most heinous of murders in most jurisdictions. And there are ways that they try to cabin the use of first-degree murder, usually by requiring that it have premeditation and malice aforethought. And so along with that, right, are all the considerations that go to intentional manslaughter. So in just about every jurisdiction, murder can be mitigated to manslaughter where there's adequate provocation, leading to a heat of passion, and with insufficient cooling time. And so that our manslaughter definition is actually better than that now. Thank you to the Director Schmeckel and staff who drafted a very nice manslaughter statute. But the main point there is that some killings are thought to be, even intentional killings are thought to be less serious. And when you have a kind of shortcut that bypasses those considerations and considerations with respect to the intent to kill, so that people who have not killed anyone, right, but are just involved in a felony that results in someone's death, you've dispensed with all of those important gradations and basically made a mockery of proportionality. And it's true that there are certainly cases where someone has been charged with first-degree felony murder where they should be charged with first-degree murder or second-degree murder or manslaughter. But make those charges and don't use the shortcut, right? Just do the work that's inherent in the proportional gradations of the traditional common law.
Right. Well, let me ask you this, and I'll welcome anybody else on the panel to jump in too. You know, I was trying to think about the example you gave in your testimony about the ex-husband stealing a stereo and accidentally creating a fire that burns the house down and kills the family, or the person who breaks the door down and viciously attacks and kills the family. In both scenarios, the family is killed. In both scenarios, it's an incredibly serious and horrible outcome. Why does premeditation elevate the seriousness of the crime within the law?
Premeditation is essentially a grant of discretion to the fact finder, typically to the jury, to determine whether or not they think the offense itself qualifies as exceedingly heinous, or whether it does not. And so there is nothing that perfectly calibrates homicide doctrine with public sentiment. But that sense of someone who is premeditated and callous and plans their killing is thought to be one of those things. Right? I'd also say that in this context, I don't want to say that the prosecutors in our jurisdiction are using felony murder willy-nilly. But there are cases where it has happened. And if you look around the country, right, there are jurisdictions where the real injustices are occurring. So you have to believe, right, that the increased discretion and lack of proportionality is just a good grant to prosecutors. And if you believe that, then there's no reason for any gradations in your criminal law. You just give prosecutors the ability to charge whatever it is that they want, right? But if you believe in that type of gradation in your doctrine and in your code, then you should put it there. So this is why Illinois is just dispensed with felony murder. It's why in California they keep trying to do it. It's why Michigan did it. It's why Massachusetts did it. It's bad doctrine, and we should just get rid of it.
Okay. Would welcome anybody else from the panel who wants to jump in on this one too.
Is this jumping generally on felony murder? Because I do want to.
I'm gonna turn to that in a moment. This was around why should premeditation,
Okay.
why does it affect or elevate the seriousness of a crime? So I'm doing that first. I'll get to felony murder in a second. And if everyone just agrees with what Professor Raymond said, that's good too.
So the model penal code does not divide murder into degrees. And the commentary to the model penal code says the idea that premeditated killings are inevitably worse than other kinds of intentional killings doesn't survive analysis. So I certainly agree with Professor Raymond that if you look at many states, many jurisdictions quantify premeditated killings as the worst. But I do think it's significant that the model penal code does not agree with that analysis.
Okay. Mr. Schmeckel?
Yeah, just a couple of points. One, we early on had some discussions in the advisory group. It might have even preceded Alana joining. And current district law definitely puts a very minimal bar as to what level of what deliberation means, right? Premeditation, deliberation. It might sound like advanced planning, right? That this is different. It is a momentary consideration and turning over in the mind of what the person's going to do. So again, for what this distinction means, it's a very perhaps important, right, distinction, and it's been one there in current law. We carried it forward, hearing from all sides. I think the U.S. Attorney's Office, and Ilana will correct me if I'm wrong, I think their position was, no, that distinction makes sense to us. Let's keep that distinction. So we carry that forward, but under current case law, which we don't change, that deliberation and is a very minimal requirement, the difference between first and second. The only other point I want to make it right now is the importance of that first degree, second degree. It's not the label, they're both murder. What matters is the penalty. And under current district law, first degree murder carries a mandatory minimum of 30 years, which we heard today the U.S. Attorney's Office continues to support. Second degree murder carries no mandatory minimum, right? So that is a huge difference, right? And that difference plays out, and I think others can testify to this, in very significant ways in how charging and plea negotiation works. As one of the witnesses that we heard, and I think it was the day 2 hearing said, look, if you are looking at a mandatory minimum of 30 years for a charge, it doesn't matter what you did. You have to think about a plea deal to a slightly lower version, second degree murder, that has no mandatory minimum. And if you're a first-time offender, the sentencing range under the current guidelines, you're going to get dramatically fewer years. Single digits instead of this mandatory minimum of 30 years. So that is a key part of this conversation, and it's part of the process, right? That we had in all these conversations. It's tough to talk about the elements of the offense and the grading. And then also in the back of your head, what's going on with penalties, right? How does this influence that? And here it's just an incredibly important line between first degree murder and second degree murder, because under current law, that is all the difference between a huge mandatory minimum or none at all.
Okay, thank you. Well, let's switch gears a little bit towards felony murder, since we've been talking about that just a little bit. I'll try to think about it this way. I think a point of felony murder, what I think people would agree with, is that when an actor, and I'm going to try to use the RCCA's term here, a term of art, the actor, commits a dangerous felony and another person dies, that's incredibly serious. Hopefully there's no disagreement there. It's certainly more serious than the commission of the dangerous felony standing alone. But when an actor doesn't actually kill someone or help another person kill someone, the question would be then is, how is that as bad as if the actor had purposefully and deliberately killed someone? I might direct that first to Professor Brayman, who has kind of testified a good bit about this topic, but then Ms. Hankins, Julo, if you want to jump in on this at some point too, and so would welcome others.
I mean, the answer is that it's not, right? Those cases should be distinguished and charged appropriately. And I think, the point here is not that they could be charged appropriately, but they should be graded appropriately by our code, right? Not under the discretion of prosecutors. And the additional piece here about accomplice liability is just, the idea that people who are just accomplices in a felony can be on the hook for felony murder is really iniquitous. And I think it's very hard to figure out a way to justify this doctrine. There are not experts around the country who are arguing strongly on both sides of this. This is something where we have an anachronistic code, an anachronistic law, and people who think about it get rid of it.
Okay. Ms. Hankins? And then Ms. Weiser, I might try to bring you into this too.
So
everyone can know where I'm going to go.
So much. So one thing that I don't want us to gloss over, so PDS's position is that felony murder should not be in the code at all. Not even what's in the bill, which is certainly better than the current law. That doesn't mean that, right? So one, as Professor Brayman says, and in response to sort of the examples that Ms. Suttenberg gave, right, which is some of the offenses when you come up with the scenarios could be charged as first-degree murder, could be charged as second-degree murder, maybe could be charged as manslaughter, right? So it is not that there's sort of like no ability to hold someone to account, hold someone responsible, punish somebody for a death that happens while they are committing a felony. If it's premeditated, if it is knowing, they engage in conduct knowing it creates a substantial risk of death or intending to cause death, or even act recklessly. I don't remember the language, but it's like with extreme indifference to human life, right? All those are sort of forms of murder. But the revised criminal code also has negligent homicide in it, expanded over our current law. So even if it is negligence, which, as I said in my testimony, is not aware of the risk, not aware that your conduct is creating a risk of death, should have been, but not aware. It's an accident. Even then, our code says you can be held liable for that. You can be punished for that. You can be convicted of that. That can be charged. So we're not sort of saying do a robbery and then somebody dies in the course of that. Whoops, well, nothing happens to the person. They're going to go down on robbery and they can go down on negligent homicide. It's not that we're saying there is no possibility of holding someone to account. It's the cheating part. I think the language that Professor Raymond used was like a shortcut. Maybe
Shortcut,
cheat
yeah.
isn't but it is that. It is sort of this, you know, it's like in the jury conversation. When do you sort of short circuit what process rights people get? When do you make proof easier, right? Which is well, if I want to talk about the prosecutors, the U.S. Attorney's Office compromise, which maybe I don't do now, but it is this sort of point of when is it all right? When do we draw the line to say someone who might be innocent goes to prison versus someone who maybe is guilty doesn't go to prison? And felony murder just says maybe you didn't intend it, and maybe I wouldn't be able to prove premeditation or knowing or even recklessness with extreme indifference. But I definitely want to make sure you go to prison and therefore felony murder. And that's the shortcut to 30 years in prison versus being able to charge negligent homicide.
Okay. Ms. Weiser, can I pull you in from the OAG side of things as a prosecutor? Help us, what's your reaction?
Well, my initial reaction is I wish Dave Rosenthal were here because he because he knows this stuff so much better than me. And honestly, it is such a complicated criminal legal theory of liability that it takes a long time to learn and understand it. And I am still, and I won't tell you how many years I've been practicing law, but it's a difficult concept to get your head around. And I think it is difficult because of sort of the inequities that Professor Brauman talked about, right? Like we want people to be charged for the conduct that they do, and we want people to be prosecuted for the conduct that they do. And so it's very hard to understand why it could possibly be that we would charge people with the most serious thing, a first-degree murder, essentially, right? Felony murder is first degree. When they didn't even ever envision, have in their minds that that is something that they would have contemplated would have happened in the course of whatever conduct they decided to do. And so I think the commission's decision, first of all, to move felony murder from first degree to second degree makes sense, right? Because I think second degree sort of captures a lot of conduct that we're talking about here, right? That there might be recklessness, there might be, and also to Ms. Hankins' point, the negligent homicide is also a tool that we as prosecutors can use if we can't make the facts of the second degree. But also, you know, the commission talks about wanting to make sure that that there's a belief, like, and I'm talking about sort of accomplice liability, right? That the accomplice believes that something is going to happen, right? The accomplice believes that a murder is going to happen, and that it should be a requirement that the belief element be proved by the government. I think the Office of the Attorney General would say that makes some sense, but we would say it has to be a reasonable belief. We would want to characterize it as just not any belief in the universe, but a reasonable one. And then generally, I think that we also know that there are other offenses that can be charged, right? Like accessory after the fact is a charge that you could use for a getaway driver, for example. There are other, and the negligent homicide charges, something that could be used if the facts bear out that. It is a premise that we adopt that you have to be charged for the conduct that you do. And what the commission has done, I think, makes this a lot clearer and makes it a lot more approachable, and frankly, makes it a lot fairer for the folks that are in the situation where they're being charged with this conduct. And you can, I mean, I guess I'm going to go off on a little bit of a tangent, but there are several people that have benefited from IRA, right? So some young people that have benefited from IRA that were charged with felony murder for a role, like a minor role in a homicide. Those young people spent 15 years in jail sometimes for being the getaway driver. And is that really how we want to punish people who commit those sorts of things? We've seen what happens to people that serve these long sentences because of felony murder charges. And so the office does believe that what the commission has presented is reasonable, and we would just want to add that reasonableness prong to the belief element that's been articulated in the statute as it's written now.
Yeah. Okay. Yeah, I think you make a good point around at least some of the individuals that have been successful in their petitions through IRA. I think about Helene Flowers, for example. And one overarching policy part of this conversation is, in what way are we advancing public safety? And was public safety served in that case? Let me, all right, so if we're following this, Professor Brayman's earlier example again of the break-in for the stereo shorts out the fuse, which somehow sparks and burns the house down. The idea there is that the intent was to get the stereo. The intent was not to do harm and have the family ultimately killed. But the family's dead. And so negligent homicide is still a charge. So you're not just going to get them on the theft of the stereo, that there's many other charges that go. It's a distinction between the intent behind the loss of life. So if we've used the example of the getaway driver or things like that where you thought you were going in for a burglary and instead it's something else. So it sounds like the felony murder rules impute an intent to an actor that they may not have. So I just want to make sure I'm going to walk through with the panel here. Love to have each of you explain. Is that fair? Is that not fair? I think Professor Brayman, you've kind of laid that out already, but I don't know if you want to. I feel like you might be doing a repeat at that point, but I would love the rest of the panelists. Mr. Schmeckel?
Sure. Just briefly, I think this is key to what you're getting at is all that we're talking about for felony murder is for anybody who hasn't had to deal with this law. It sounds like it's liability when a person commits any bad felony and there's a death. And that's not the case, right? So normally what happens, and will continue to happen under the RCCA, is when the conduct, you look at the conduct and you can charge, prosecutors can and will charge, whatever charges fit that conduct. And so it might be a robbery, a kidnapping, a burglary, a sex assault, and the murder charge, whichever degree is merited by the mental state, which is how we grade degrees of homicide. Okay, so that's the norm. That doesn't change whether you have felony murder or not. You can be an accomplice under the RCCA and any of these jurisdictions where they've already eliminated felony murder, you can still be an accomplice to any of these levels of homicide or any other crime. You still have regular accomplice liability. You still have regular liability for the homicide or whatever else. The only question is, for felony murder, do we provide an exception? Because a death is such a terrible, terrible result, right? And do we provide an exception in those cases where even though the person didn't have what we would normally require everywhere else, and for regular homicide, a mental state of either recklessness or knowledge or purpose, or even this kind of notion of a purpose plus deliberation and premeditation? Do we want to make an exception and say, yeah, you didn't see that coming, but still we're going to give you the higher level charge? This is all about an exception. So really just to frame that, and it's an exception about intent. We're imputing intent in order to get a higher penalty. That in the end, that's what this is about. We preserve accomplice liability. We preserve all these other charges. We've expanded, actually, at the bottom, as the Public Defender Service noted, liability for negligent homicide, which right now exists in the district in a different form for really just automobile-related homicides. We're having a more general negligent homicide statute. That's the context that we're talking about here. Do we provide an exception to bump up the penalty? That's all it's about. And one point I would raise is look, the liability somebody is going to face for a robbery or sex assault or any other serious crime, which also involves a death, it's going to be decades, right? Where the person is physically injured in a severe way. We can talk about some of these other statutes, but they're going to be facing major time. They may still have, again, I didn't even mention attempt liability. There's attempt liability also out there for many of these instances. So we have many other theories of liability that remain on the books. And some jurisdictions have said, that's plenty. We don't need felony liability at all. In this case, we recommended a compromise approach. I realize, some are calling for a complete elimination. Some are calling for more of a defense, but that's what's at stake.
Right. Okay. And let me tell you this, I want to turn to accomplice liability in just a moment. I also recognize that, like me, you have likely been sitting in that chair for the same amount of time that I have since 9:30 this morning. And it's a little after 1 o'clock already. What I was going to do is take about a 10-minute break if we can, so everybody has a chance to stretch their legs or grab a snack bar, whatever needs to happen. And then I want to be able to turn to accomplice liability because Ms. Suttenberg had also raised a recommendation in her testimony I want to make sure we spend some time on. So if I can, if there's any other responses just to the felony murder question I asked about what is that intent? And then we'll take a 10-minute break, and then I want to turn to accomplice liability after that. I have a hunch people just would appreciate maybe a couple of minutes break. Mr. Schmeckel, you kind of teed up what we're going to turn to in just a moment, but before we do that, was there anybody else who wanted to touch on the felony murder question I asked around the imputing intent to an actor that they may not have had, and are we comprehending that in a fair or unfair way?
I have some thoughts on felony murder, but I'm happy to share those for after a break and consider it more holistically. Okay.
All right, then why don't we do that? It is 1:10. So this is just, first off, just before we take a quick break, thanks to everybody. This has really been such a deep, substantive conversation. I'm grateful for it. Just so that everybody has a chance to stretch their legs for a moment, why don't we take a quick 10-minute break? So we'll come back at 1:20 and then be able to pick right back up where we left off and try to hit through a couple other substantive issues before we wrap up. So thank you all very much. Again, for the record, the time is now 1:10 p.m. and we're going to take a 10-minute recess and reconvene at 1:20. All right, we are going to start reconvening in just a moment. I do want to note, my understanding is that Deputy Mayor Geldart has a All right. Good afternoon, everybody. The time is now 1:24 p.m. We are reconvening after a very brief recess. And again, thank you to all of our panelists. Where we left off is we had begun talking around the recommendations around felony murder, and then also had been moving towards the accomplice liability for felony murder. Ms. Suttenberg, I'll start with you. I had a question I was going to pose, and you had mentioned you wanted to jump in on this, so I'll just kind of ask my question and then hand it to you to help jump in and add what you'd like there. So if I understood your testimony, USAO's recommendation, which is different than what's in front of us, would be for felony murder accomplice liability is presumptively subject the actor, and again, I'm trying to use the term of art from the RCCA, to felony murder liability, and the actor or the defendant, since we're now in the posture of the prosecution, would then have the burden of proving that they did not intend to kill anyone. Before opening this point up to the panel, I want to make sure I give it to you. One, am I accurately describing what I thought I heard? And then I want to let you have a chance to kind of respond more broadly as well. If I am capturing that right, want to try to understand the tension that will exist between the prosecution's burden to prove each element of the charge by proof beyond a reasonable doubt, and the existence then of an affirmative defense. How do you help draw the lines between impermissible burden shifting, permissible affirmative defense, and kind of we'll hand it over to you to be able to talk about that.
Sure, thanks for the question. So I did just want to start, there's been some conversation about negligent homicide, and I did just want to take a moment to commend the CCRC on that. I really do think that was a positive development that can create some liability for a homicide related offense where none is possible under the law. So I did just, want to take a moment to focus on, I don't mean to be all critical of the CCRC's work today. I did want to kind of commend that change. I think it does fill a gap in liability that exists with the current law. As we've kind of discussed, there are different gradations of murder depending on the mens rea assigned, right? Premeditation being the most serious. You premeditated and deliberated before committing this murder, and many others along the way. As to felony murder generally, the RCCA's proposal is to move it from first-degree murder to second-degree murder, and that is a significant change. But notably, they do not propose eliminating felony murder altogether, and I think this is, been the subject of robust discussion within the CCRC just about felony murder generally. But they do not propose eliminating it, recognizing that there are situations where murder liability should attach for the commission of what is inherently a dangerous offense when somebody is killed during that offense. As to accomplice liability would exist for everything else, right? We're as Mr. Schmechel indicated, this is a very narrow exception that we're talking about in felony murder. It's generally a principle that applies throughout the rest of the code, both under current law and as proposed by the CCRC. So it's an essential part of liability generally, and without accomplice liability generally, there would be gaps in the law when you have acts perpetrated by more than one perpetrator or when people are acting together. So, for most offenses, it's an important part of the code. Our compromise position, I did just want to provide a little bit of context as to how we got here. So the initial CCRC's recommendation was just to eliminate accomplice liability for felony murder. The U.S. Attorney's Office filed, and I don't recall offhand if anybody else filed comments on this. I apologize. It might have just been us. But we filed comments indicating, the tremendous gaps in liability that would cause. And we, my colleague who is here today with any questions, murder specific, assisted with that, really focusing, and we did file, pretty extensive comments on the situations that we thought would not have murder liability absent this rule. In response to that, the CCRC created this affirmative defense. And I actually tried to draw directly from that language. Ms. Weiser, I think, proposed a really helpful addition that the belief be reasonable. And I think that that's an appropriate addition. So I appreciate that change. But this was where we're drawing from essentially a compromise position that was suggested by the CCRC in previous drafts. And then we actually believed that was a compromise position, so didn't, oppose it. And then it was changed to a defense rather than affirmative defense. And then in the final draft, it was removed again entirely. So we're just kind of proposing going back to something that was actually originally proposed by the CCRC, that we think that balancing all of the interests here is an appropriate compromise. It is not, was not our starting offer, if you will. But we thought that it was it was an appropriate compromise, recognizing the complexity of this situation generally. And I'm sorry, you also asked about the burdens. Let me get to that.
Sure.
So the CCRC, throughout proposes what are defenses, which is, and Richard, please feel free to correct me if I'm wrong about any of this, but essentially when there is any evidence, not just opening statement, but any actual evidence, then the government has to prove the absence of that beyond a reasonable doubt. That's contrasted with what they've styled as an affirmative defense, which is something that the defendant has to prove by a preponderance. Both exist throughout the RCCA, and we've had discussions, with advisory group members about what's appropriate where. We've actually even at times said, it shouldn't be an affirmative defense, it should actually be a defense that the government should have to prove. So we acknowledge places where we actually think the burden is more appropriately on the government. But in this situation, we believe that it should be an affirmative defense consistent with the CCRC's initial proposal, because there are many situations where we just aren't able to prove who actually committed the lethal act, right? Some of the examples I gave in my testimony, you have two people firing a gun at the same time or firing at the same time during the course of a felony. We don't know who committed the lethal act. In some situations, the defendant may be able to offer evidence, that could support them not having committed the lethal act, and that's why an affirmative defense would be appropriate. I will also note, though, when we're making our charging decisions, we don't make charging decisions in a vacuum. If we think that somebody can meet the elements of an affirmative defense, we don't wait until trial necessarily to make them meet that burden. Of course, there are times when we don't know, and at trial there is evidence that comes out that we're unaware of, or that we think that we can meet and prove beyond a reasonable doubt. Obviously, we're often aware of defenses in advance of trial and believe that we can prove guilt beyond a reasonable doubt nonetheless. But that is something that we can account for when we're making our charging decisions as well, the existence of this affirmative defense.
Okay, thank you. Mr. Schmickel?
Yeah, and I know this is complex, and obviously we're not going to be able to wordsmith things. Goodness knows we had a hard time doing that when we were all together in a room a couple of years ago, let alone at a hearing. But I think some of these principles we can communicate and talk about. And one is I wanted to say, our recommendation on maintaining felony murder is, to my recollection, doesn't address any gaps or change any gaps in the sense that a person would not be criminally liable, period, without this. What it does instead is it changes the label of some of these acts so that it's going to be under the murder label, and it's going to change the penalty, right, that corresponds with second-degree murder. Those are the two things, and I want to be really clear about that because hypotheticals are tricky. We've spent hours with this group, trying to flesh these things out and talk about them. But, for instance, a shooting, the example of two people shooting at a person, the person dies from the bullet of one. It can't be proven for whatever reason which shooter's weapon was the one that fired the bullet. This is a pretty square issue that proving beyond a reasonable doubt that person A or person B was the one who committed the lethal act is not possible under the evidence, under the hypothetical. What do you do in a situation with that? And I think it's important to recognize that anybody shooting at anybody is an attempted murder, right? Like both would be subject to attempted, probably first degree or second degree murder charges. Again, we'd have to fill out all the hypothetical to get it, whether it's a manslaughter charge or something else. But it'd be reasonable to say it's at least an attempted first or second degree murder. So again, we're not talking about situations where the existence of felony murder makes a difference between no liability at all for the conduct. Instead, it's a matter of what's the label and what's the penalty. And it actually, once in second degree, which felony murder would qualify for, with no mandatory minimums involved, there's going to be a range. It's going to be a higher level, but it's actually not going to be that different than a person who commits a serious felony like, again, a robbery that involves a serious bodily injury. That person's looking for almost 2 decades of liability there anyway. So the difference between that and second-degree murder isn't that much. It's significant. I don't mean to undermine it, but I also want to note that a person who's engaged in this sort of conduct is often, not always, going to also be under these other charges subject to similar imprisonment penalties. But I'm sure others have thoughts on that too.
Can I?
I could
so-
just offer,
Ms. Sundberg and then Professor Brayman after that.
and if I could just offer one comment on the attempt. I recognize that the RCCA's language on attempt is intended to encompass some situations where, it might have been charged as assault with intent to commit another offense in other situations and kind of other things. But I don't necessarily know that this situation would satisfy the attempt standard in this case, and I don't know that it would attach there. You still have to, under the proposal, under the RCC's language, act with the culpability required for that offense. And if we couldn't prove premeditation and deliberation, I don't know that there would necessarily be liability for attempted first-degree murder either under the set of facts that felony
Right,
murder.
but what we've got is a hypothetical that is obviously resulting in a death. So I don't know why we're talking about attempt. You've got 2 people shooting, presumably someone dies, or we wouldn't even be talking about felony murder. At a minimum, that's got to be recklessly with extreme indifference to human life. 2 people shooting, aiming at somebody, right? That if that's not knowing, it's at least reckless with extreme indifference. And accomplice liability then gets you there. And you don't have to prove then who's the principal, who actually did it. You can actually prosecute both of them as an accomplice to the other, right? So we've got it. It's not like there's no offense here. It's not like there's a gap here. It's that you don't get to charge felony murder. That's the only, but that doesn't mean a gap. That just means you have to prove something else.
I agree with you that there could be situations where second-degree murder liability would otherwise apply. I agree.
Including that example that you gave.
I think it depends on the facts of the case, and I don't know that there would necessarily,
Well, I'm just going on the facts that you gave, which, as Richard said,
Fair. Okay, fair. All right.
Okay.
Professor Brayman, I wanted to make sure I turned to him.
But also, just to be clear, if they're both trying to kill that person and they're working together, they both can be charged with first-degree murder, right? As accomplices or co-conspirators, or this is not a circumstance where someone's just going to walk away with that. And as Laura's pointing out, the minimum that I think would result from 2 people trying to kill someone and one actually succeeding would be attempted first-degree murder and first-degree murder. Those both are where people are intending to, right? And as Richard pointed out, this point about premeditation, the law is basically, the doctrine is that no time is too short for an evil man to fix murder in his mind. And so there's no, precise line that's drawn there. It's not you don't have to have, a long notebook planning the murder. People are convicted when they impulsively, right, and very quickly decide that they want to kill someone. So it's not like there's this huge gap here. There just isn't a gap.
I will say this: I have definitely learned in my time that there is danger with any hypothetical that gets tossed out there. So I appreciate that the hypothetical is coming from a space of saying, "Hey, let's think this through from different sides." So I'm going to take that as what the intent was. But I also appreciate the points of trying to say, okay, well then, if not that, then this within the RCCA framework. So Ms. Sundberg, I definitely want to make sure you have a chance to kind of respond to that. If that, and again, any hypothetical anybody puts out, we can, I know we can pick it apart. So, but I do want to get kind of your feedback too.
Sure. The only point I wanted to make was something that I alluded to in my testimony, is that murder is an incredibly unique crime because you don't have a victim to tell you what happened. That's not the case with, virtually every other crime where there is a victim who may be able to tell you what happened. there's some exceptions, you know what I mean? But that makes, you know, a lot of murder cases very circumstantial when it comes down to it in reality, necessarily, because you don't have someone to say what happened at that moment. This person fired a weapon at me and said this. And so, you know, you can look at various facts. Where was the victim shot, right? And kind of where the bullet wounds were, or kind of other facts that inform a circumstantial case and what happened. But I just wanted to note that it is such a unique crime because you don't have a person to tell you what happened to them.
Okay. Let me, and I realize Ms. Suttenberg, I may be triggering with this, but all right. So earlier we heard the comment of saying, does felony murder act essentially as a shortcut? So, and again, full well acknowledging any hypothetical is going to not be, you know, perfectly put together if it's a hypothetical, but why wouldn't I make the argument back to say, well, the example of that or any other example, felony murder, that's exactly my concern, is that felony murder becomes the shortcut for what could be more complex or more difficult, but there still are a lot of charges there to be able to hold someone accountable for the harm and violence that was done.
Sure. So recognizing that there are various levels of murder liability that could apply depending on the mens rea, I think this is really kind of a question of it's really a question for the community, as a lot of questions of criminal law are. What should a person who commits this type of a crime be accountable for as a matter of labeling, as a matter of punishment? Should it be called murder? Should it be called robbery? And, you know, I think that is a question for the broader community to resolve. You know, if you commit one of these labeled very serious offenses that are kind of designated by the essence of them being predicate offenses as inherently dangerous offenses, if you do that, and while you're doing that, someone is killed, does the community think that that should constitute murder, or should it constitute robbery? And I think that's, you know, we think, you know, felony murder kind of allows that, but I think that this is a broader question just for the community as to what the criminal law should look like. Or should it be manslaughter? You know, I'm recognizing that there's various levels of murder and homicide liability.
But isn't that why we have accomplice liability for that murder, or we have other pieces? So in that example, it's going to be a robbery, that there are other charges that can be brought for the outcome that takes place.
Yes. Yes, if there is accomplice liability for, you know, everything else other than felony murder, general accomplice liability under the RCCA's proposal, you know, all accomplice liability applies to all offenses. Yes. And it's kind of the general rule that there is accomplice liability. We're talking about this very targeted exception and not having accomplice liability apply to it. We're trying to offer a compromise position consistent with kind of how this has gone. But the general rule is that accomplice liability exists for every crime.
Let me, Mr. Speck, I'm going to come back to you. I know that I'm about to lose. Mr. Butler has to leave in just a couple of minutes. So if I can, Professor Butler, one question to you, and then again, we appreciate your time today if you've got to step out. One of the arguments that I have heard when people talk about what they perceive to be as an advantage of having felony murder is that it purportedly would hold accomplices liable, but also create deterrence. Is there any evidence that that you have seen that holding accomplices liable when their partners actually do the killing would actually deter people from committing crimes?
Absolutely not. So the problem is that in a felony murder context, the killing happens as an accident. You cannot deter an accident. Deterrence is a model that suggests that people who are contemplating crime are rational actors, and they think, I want to commit this crime, but I'm not going to because I don't want to be punished. If you're not capable of having that thought calculus because you don't know that you are committing a crime, you're not trying to commit a crime, then you are not capable of being deterred. And that's why the vast majority of legal scholars are opposed to felony murder rules at all. If we think about retribution as a justification for punishment, the idea there is that people should be held responsible for the harm that they intend to do. So if it's an armed robbery situation and when someone dies, yes, punish the person for armed robbery, possibly punish for negligent homicide, but don't punish for murder if they didn't have the intent to kill. It's a legal fiction with devastating consequences. And since I do have to go, I want to say thank you so much, Mr. Chairman, and thank you to every person on this panel, as well as the staff of the CCRC. I'm proud to be a citizen of a jurisdiction that considers these issues with this level of diligence and appreciation of the high stakes to our democracy if we do not move forward. It's been an honor to work on this project, and I will continue to offer the council any assistance I can as it considers this vital proposed act. Thank you very much.
Absolutely. Thank you so much. We appreciate your time today. Mr. Schmeckel, you had your hand up, and Ms. Hankins, you had your hand up, so I'll come to you right after Mr. Schmeckel.
Sure. I was just wanted to briefly follow up on a question about kind of what people say about this, right? And I'd point out again our survey. We did ask questions about felony murder type scenarios, and with a grain of salt as for the limitations of the survey, the ratings that we saw were very much that the felony murder scenarios were less than essentially our description of manslaughter. Falling in the almost squarely in between where manslaughter would be, that is to say, a killing of somebody in moment of extreme distress, and what is an aggravated assault or a serious bodily injury that's going to hospitalize somebody and might risk death, right? It fell in between in that zone when we were asking what district citizens want or how they would rate the relative seriousness of this. Now, again, many other considerations, but I wanted to add that into the conversation because I think, again, we need to have some anchor point. And we've seen, again, some jurisdictions say shouldn't be there at all. Some have extremely high maximums and use it a lot for felony murder. So when you're looking for trying to reassess this, I point that out as one source for trying to rate what do district voters think about the relative seriousness of this offense.
Okay, thanks. Ms. Hankins?
So I think a different hypothetical might be sort of more useful, right? Not the one where the death is more of an accident, right? So as Ms. Suttenberg sort of phrased it, if you sort of said to the public, if somebody commits a murder and a robbery, do you think they should just be punished for the robbery? Well, that's not what the question is, right? Because the question is it something that should be called murder? So, imagine an armed robbery where before the robbery, the person who's going to be holding the gun unloads all of the bullets, or at least they believe they do. And they're like, I do not want to shoot anyone, but I want to appear, I do want to have a gun in this. And they do the robbery, and that could be it, right? Nobody dies. We would just call that an armed robbery. We also have the other version where sort of like that person then at the end is like, you know what, I'm going to kill you. And then they shoot and they do that, right? That's probably first degree premeditated murder. But we also have the person who sort of has made the effort to take out all of the bullets. And as they're leaving, they trip and they fall and they drop the gun. And it turns out they missed the bullet that was already in the chamber when they were unloading, and the gun goes off and it kills a bystander, right? It's an accident. If those were all of the facts, we would call that an accident. Now, we might call that negligent homicide, right? But the question is, do we punish that, right? That trip, fall, drop gun, that that makes the gun fire. Is that the same as a decision, oh, you're a Cowboys fan, I don't like them, I'm going to shoot and kill you, right? Is that the same as murder, right? So where we are now, just with respect to what the U.S. Attorney's Office, as I understand what they're saying, is to say they agree with the proposition that If you don't commit the lethal act, you should not be found liable for felony murder, right? The question then for their proposal is, who has the responsibility for proving or disproving the lethal act, right? That's sort of the question. And then which way does it fall, right? When there's a failure of proof. If there's a failure of proof and the government had to prove the lethal act, then a person is found not guilty of felony murder, right? We still have accomplice liability and other things. The two people who were shooting the gun. We may have negligent homicide, again, where you can have accomplice liability and you don't have to prove who actually did it. If you put it on the defense as an affirmative defense, and the defense is unable to prove they didn't commit the lethal act, didn't commit the lethal act in the furtherance of, I can't remember, the defense was actually sort of really complicated. But if there's a failure of proof for the defense, what it means is that an innocent person goes to prison for murder. That's the choice. It's, okay, if you didn't commit the lethal act, you don't deserve to go. But if you can't prove that you didn't, then you're going to go to prison for murder. And that's what the U.S. Attorney's Office is proposing. When the alternative is there are other homicide liabilities, right? The alternative isn't, and therefore no one could possibly go to prison on this, to be held responsible for this death. It's they're going to have to charge something else. And there's lots of other gradations and the possibility of accomplice liability. And that's really what they're sort of putting forward. And it is hard to prove that you didn't cause the lethal act, right? There's lots of sort of, a really sort of easy way to sort of see where the burden gets put on the defense. I was looking last night in preparing for this at failure to appear, right? So this is failure to appear in court. And the current law says it's supposed to be willful failure to appear, right? Which is basically you may have known you were supposed to be in court and you really tried to get there, but something happened, right? It wasn't my fault. I ended up in the hospital, right? That's why I didn't show up in court. The way the revised criminal code does it is says you knew you were supposed to be in court and you know you didn't show up. That's the mental state. And then it's on the defense to come forward and say, let me tell you how much I tried. Right? Because the government doesn't know how much the defendant tried. That's something only the defendant would know, right? But with the lethal act, that's a knowable factual thing. And I appreciate Ms. Suttenberg's point that the decedent isn't, that when you have a decedent, you are missing a victim who can say exactly what happened. But they bring murder prosecutions all the time because there are witnesses, because there is video, because there is other circumstantial evidence about what happened, right? It's not that you need felony murder or there's just no way to have murder prosecutions. And then when you put it on the defense to have to come forward to disprove, to prove that they didn't do the lethal act, that frequently means pointing the finger at a co-defendant and saying, that's who did the lethal act. And that is also a really, really hard thing to do, right? That's one of the reasons that someone might not be able to testify about or be unwilling to testify about who committed the lethal act, because it is risky to them. It is risky to their family. It is intimidating. They may be the very youngest person in the incident. There's a lot that's forward. And in the end, right, putting it on the defense is saying, and look, if you can't, too bad on you. You may have had no intention that anyone died. You had nothing to do with this. It was an accident. You didn't intend it. You didn't know what was going to happen, but you're unable to convince me of that. And therefore you're going to prison for murder. And that's what the U.S. Attorney's Office is proposing. And that is why we argued against it and think there should be no felony murder. But certainly if we're going to have felony murder, it is exactly how it is written in the bill.
Okay. As I do throughout my hearings, if one person speaks to what they say is the motive of another entity here, I always want to make sure they have a chance here, because I don't think any of us get to say what USAO's motive is. We can believe what it may be, but let me make sure I give Ms. Suttenberg a chance to respond. And then Professor Brayman, I just wanted to touch base one more time with you on this, and then I'm gonna move on to another topic.
I don't I appreciate Ms. Hankins' comments, but I do think that, as I've kind of said, accomplice liability is the default in all of criminal law. And we're talking about a very specific carve out where, we're recognizing there can be a compromised position. Accomplice liability is everywhere else. There's lots of other horrific crimes besides felony murder where accomplice liability is appropriate. And I don't want to open any doors, but I don't think anybody's arguing that accomplice liability shouldn't apply to, rape. I mean, there's a lot of horrible crimes that accomplice liability can apply to generally. Once again, we're trying to offer this compromised position, recognizing these competing concerns. It's different from what we initially said, which is that the same rule as to accomplice liability everywhere else should apply to felony murder, but trying to offer a reasonable accommodation and, reach some middle ground in a compromised position. I think that this is an appropriate place to land.
Thanks. And Professor Brayman.
I would just frame it, I guess, the opposite way. Felony murder is the outlier, and felony murder is the bizarre piece in this set of criminal code. And so to attach accomplice liability to it just exacerbates all of the problems that are associated with felony murder. Accomplice liability still applies to every form of purposeful homicide, right? Anyone who is trying to kill anyone else could still be held liable as an accomplice if they do it as a group. And so it's not a carve out for accomplice liability. It's making sure that the bad idea of felony murder does not infect accomplice liability.
Okay. And then Professor Brayman, I guess one more final question on this before we move on for you. So if we heard earlier testimony that if I'm not saying this is my theory, but if a theory is that felony murder it can be used as a way to help deter crime from taking place, and there wasn't any evidence that would support that. If we look at jurisdictions, the root of felony murder has its roots in English law. United Kingdom, though, abandoned felony murder. Other states in the US have abandoned that. Is there any data or trends that would be associated with the elimination, or if some states altered their felony murder, that then resulted in, that can be tied to increase in violence that took place? That's Professor Brayman.
Sorry, I would say that there are some studies out there looking at the deterrent effect of felony murder. I don't want to tout them just because they support the inference that felony murder statutes actually increase the number of homicides. I think that the studies are indeterminate, even though the two studies that I have found looking at the deterrent effect of felony murder suggest that, in fact, they're criminogenic and not deterrent.
Okay.
So I would say no evidence, but if you want to look for the evidence, you can find some weak evidence that they're criminogenic.
Which would be the opposite of the argument that gets made. Okay. All right. I appreciate that. And we could probably spend, days on end on felony murder, but I feel like we captured a lot of that there. So thank you all very much. Another big topic that was within this, within the proposal here has to relate to mandatory minimums. So I want to spend a second on that. I think Ms. Weiser, I think you noted in your testimony, and I think he did as well during his confirmation hearings, that our Attorney General, Merrick Garland, had stated, quote, "We should, as President Biden has suggested, seek the elimination of mandatory minimums so that we once again give authority to district judges and trial judges to make determinations based on all the sentencing factors that judges normally apply." If that's the head of our Department of Justice, and I think that, there was a symposium in June when the USAO, relying on AG Garland's comments, stated that it would support ending mandatory minimum penalties. I guess I'm trying to square this a little bit, Ms. Suttenberg, and want to ask you if you can help me. How do we square the DOJ's and Attorney General's position with the fact that RCCA removes it, but I heard your testimony, and correct me if I'm wrong, in support of some mandatory minimums being removed, but you didn't agree with all of them. why would we keep some but not others?
Sure. So at his confirmation hearing, as everyone, including myself, has stated, Attorney General Garland said that we should consider the elimination of mandatory minimums. But notably, these comments were not made in the context of murder or violent crimes, and he didn't say all minimums should be eliminated. Our recommendations are consistent with the department's views. They're narrowly tailored to only include premeditated first-degree murder and commission of a crime of violence while armed with a firearm.
Okay. Do we believe that there have there been examples of when let's use that example, was it, you said premeditated first degree? When we've had that and there's a conviction, but then a judge goes wildly from the sentencing recommendations, and would that be like a rationale? Like, help me understand what the rationale would be. Is the rationale that it would it helps protect against what could be a judge that goes wildly outside the sentencing guidelines? Would it be because it could, a mandatory minimum would be believed to create a deterrent effect? Like, what would be the rationale then to keep the mandatory minimums?
Sure. It is a proportionality question. What do we think should be the sentence for somebody who has committed premeditated first-degree murder under the RCC's proposal that would not include felony murder, notably. So we're just talking about the premeditated and deliberated first-degree murder. I have, in preparing, I looked at a few things. The Sentencing Commission, the DC Sentencing Commission, issued some fast facts about murder. And I think that the average sentence for first-degree murder is about 37 years, 37 and a half years, maybe it was. So judges impose sentences greater than the mandatory minimum in appropriate cases. The mandatory minimum means that the judge cannot sentence below that at the time of sentencing. As you are probably aware, the Youth Rehabilitation Act does not extend to first-degree murder, but extends to other offenses and allows a person who is under 25 to receive less than the mandatory minimum. And then, as you're also well aware, there's, the Incarceration Reduction Amendment Act allows a person who's under 24 years of old to get less than a mandatory minimum sentence if a judge decides to reduce their sentence. Does that answer the question?
A little bit, but all right, what's your argument then if I were to say, well, if the average sentence then is 37 years, which is over the mandatory minimum, what good is the mandatory minimum doing at that point? Like, what's the argument to keep it if the sentencing actually is greater than what the mandatory minimum is?
Well, it recognizes that we want to, it's a judgment of the legislature. It's really a legislative sentencing. And it recognizes that the legislature believes that every person who is convicted of first-degree murder should receive a sentence no less than 30 years. It could be in excess of that up to the maximum penalty. But that is, it's a sense of this should be the penalty for this offense. And first-degree murder is actually interesting because it has long had a mandatory minimum within the DC code, which has varied throughout time, but there has always been some sort of mandatory minimum ascribed to first-degree murder in the DC code.
I would think, I would think that most, I hope, would think that a first-degree murder warrants a more severe penalty, than something else, right? Like, and so what I'm trying to kind of make sure I wrap my head around is, if the courts are playing out in a way that is not just consistent with what the mandatory minimum is, but a little bit more than mandatory minimum, then what is the value added from a sentencing perspective of creating a mandatory minimum, other than the legislature just feeling like, I pat myself on the back and say, yeah, I told you this, I feel this is stronger, this is more serious than something else. And so therefore I'm making this requirement, but in reality, the judges are doing more than that anyway.
Sure. So it does recognize, the legislature on behalf of the community saying, we think that this should be the sentence for, murder or for another offense. Maximum sentences represent the highest level that you can receive, and a minimum is the legislature essentially saying this should be the sentence at a very minimum. It's essentially the community saying this should be the sentence as enacted by the legislature.
Okay. Mr. Schmeckel, anything you wanted to add to that from the commission's perspective? Matt,
Absolutely.
I know you wrestled with all of this throughout the process.
Yeah. So I think many points could be raised about mandatory minimums. And the number one thing is that when are mandatory minimums having an effect? They're having an effect at the lowest, the cases that would otherwise receive low sentences. The point of mandatory minimums is to restrict judges to use their judgment, judicial discretion, as the Attorney General gave a shout out to restrict their discretion as to looking at the whole case and what a person deserves, and instead saying, no, by fiat, there is no conceivable case of first-degree murder in this instance that deserves less than 30 years. That stance, that a mandatory minimum prevents judicial discretion being used for those low-level cases, has been repudiated throughout the academic community, as I said, and practitioner community. I don't want to make this sound as if it's some scholarly thing. The American Bar Association, the American Law Institute, through the very recently assembled new sentencing recommendations, all condemn the use of mandatory minimums. The nearby Virginia State Commission recently put forward recommendations to remove mandatory minimums. This is happening everywhere as there's a realization that what these do is for the bottom, the least serious offense that might otherwise go below whatever the mandatory minimum is. That's where it's saying no. Despite what the judge would otherwise say, it's requiring to go higher. And let's be clear, this is a matter up to of who has control, right? Does the judge have control over the sentence and have judicial discretion to view the person in front of them, the facts of the case in front of them, however strange they may be? Or is it up to the prosecutor who brings the charges, who has the choice between, as I said before, first-degree murder and second-degree murder, that very distinction between premeditation and deliberation, which can happen in a moment. Prosecutors choose which charge to bring, and by doing so, have the choice whether to put on the table, right, in a plea bargain a situation, a charge with the 30-year mandatory minimum or zero. That is a truly a hugely influential factor in plea negotiations. And right now, what mandatory minimums do is they give the discretion of whether to pursue that and how it gets used in the hands of prosecutors versus judges. And that's the reason why you have this, like, the practitioner community, the academic community, the judicial community, the judicial conference have all said mandatory minimums need to go, because the safest way systemically to make sure that people are treated fairly is to put that in the hands of judges versus prosecutors.
Can I bring in, Ms. Weiser, can I bring in another prosecutor into this? Because your testimony diverged a bit and was in support of this.
I mean, I think, the Office of the Attorney General is of the perspective that we need to give our judges some discretion back, right? That they are the ones who are best equipped and trained to evaluate what an appropriate sentence is. They are the ones who are who listen to the trial, who hear the evidence, who respect a jury's verdict and know about social factors and history with regard to the defendant in a way that mandatory minimums essentially just evaporate, right? Take away from a judge. Doesn't matter what happened. If there's a conviction, if there's a finding of guilty, their hands are tied and they are only left with the opportunity to go up as opposed to go down. We entrust our judges with this incredible power. We should let them exercise it. And that is really sort of the nut of what our office's perspective is on this.
Right. It feels like part of what we're trying to have a conversation around and wrestle with, and let's acknowledge the wrestling, is if a 18, 19-year-old commits a homicide that first degree homicide, do we believe that they have no opportunity to return until they're 50 years old? And is that justice? Is that appropriate penalty? Is that in the interest of public safety? And I think we're wrestling with that. And are there instances that action taken by that 18, 19-year-old may warrant the average of 37 years? And are there instances where that action would be less than 30? And do we trust the judge to make the decision about which one it is?
That's right. And I think consistent with what Attorney General Racine has tried to do, we've introduced some pretty bold legislation with regard to Title 16. And, when are we going to charge children as adults? And are we going to, keep them in the family division where we think that there's a chance at rehabilitation? Or, should it be the normal practice that kids that are 16 or 17 get charged as an adults and are at risk of being sentenced to a mandatory 30 years in jail for a first-degree murder? These are really hard questions, tough questions to get our head around. And I'm sure, obviously we can't forget about the fact that there's victims and real loss here, right? Like, we're talking about a loss of human life and families who will never be the same, and who we're losing people to these incredibly violent crimes. But we have to be careful about who it is we're giving the discretion to make the ultimate decision. And I think consistent with that, we believe that it is appropriate that judicial officers are the ones that make those decisions.
Okay. And Ms. Hankins, you had your hand up?
I just wanted to make sure that we didn't forget that we have sentencing guidelines in the district, and to sort of explain how the guidelines work, right? When there's a new offense that's created, or after this, like, everything will have to be sort of resorted. They're put in relation to each other based on the statutory max, right? So first-degree murder, whatever the penalty is going to be, it's going to be the most serious. It's the most serious crime we have. It's always at the top. And then something else is really low. I don't remember what ends up being in the sort of lowest category on the sentencing guidelines. But it's not just the top, right? Each box then sort of says, here's a range, and that range is, here's where you're going to put the prison sentence. And so the bottom of the first-degree murder sentence range that's in, right, you go to that part, that row on the guidelines, and it's that bottom, judge, this should be the minimum you give if you're complying with the guidelines. Then that's higher than the crimes that are less serious, right? So it's not as if first-degree murder goes to a judge, and if you didn't have a mandatory minimum, and somehow you didn't trust that a judge would recognize that premeditated murder was a really, really serious offense, that if somehow as an individual, we sort of didn't trust that a judge could recognize that and punish it appropriately, but individualized, there's still the guidelines that say, basically, unless it's mitigated, and even the mitigation is actually pretty strictly written, then you've got to judge, if you're complying, give at least this much, right? So in some ways, we actually have guidelines that act in some ways as mandatory minimums. They're not mandatory in the sense that the guidelines are voluntary. And even if you're complying with the guidelines, there are mitigating factors the judge can consider. But it's not as if a first-degree premeditated murder comes before a judge, and if we didn't have a mandatory, a judge would be like, well, probation. The judges in the Superior Court are like over 90% compliant with the guidelines. They're giving sentences in the range, and the range for those serious offenses say someone's going to prison. They're not getting out on probation, and they're going to prison for a really long time, certainly in comparison to less serious offenses. So getting rid of mandatories doesn't all of a sudden mean people are committing first-degree premeditated murder and they're getting probation or they're getting 2 years in prison. They're still going to get a lot of time, and certainly relative to where everything else falls in the guidelines. And that's the system, and it's working. I think people are generally really pleased with how the guidelines are working, which is why the judges are compliant with them. And we will still have that structure, even if this bill passes, even when the bill passes.
And sentencing, I appreciate agreement with sentencing guideline. I think we are somewhere in the ballpark of like 97% compliant with the sentencing guidelines. So there are very few outliers that take place. Okay. All right, then let me turn to, since we're trying to tackle all the really good controversial ones in here. Mr. Schmeckel, did you have something?
Yeah, and I wanted to add in just two pieces, because while our focus has been on numbers in mandatory minimums, one, I want to point out they do real work for first degree murder. By our statistics, about 25 to 50% of first degree murders, can't be more precise given the analysis we were able to make public under the court's rules, but are at that minimum, right? So judges are hitting that floor in those cases. What they would do if that floor wasn't there, I don't know. We also don't know the facts of the case. And as I mentioned in my introductory comments, when crafting penalties, you really have to think not of the typical case, right? That's what the guidelines are there for. We have to think of the really unusual cases where, and both at the top and the bottom, make sure that the code provides a proportionate punishment. And you might think for something like first degree murder or aggravated first degree murder, that there is no situation where, right, somebody can should be subject to a lower term than 30 years. But I want to say that there are, you really, this is the horrendous kind of difficult thinking that you have to go through. But in the district, we have an assisted suicide law. It is very scripted. Anybody who deviates from the protocol for that and assists in a suicide is, if it's an elderly person, guilty of an aggravated first degree murder. If they are on its face, on the statutes, right? So we've really got to think, is that going to happen? Would that charge be brought? I don't know that it would. I would hope, and I dare say, judicial or prosecutorial discretion would come in. We shouldn't see unusual cases like that be charged that way. But that's not what the system's set up to do. The code has to be set up in a way to prevent, right, unjust liability being imposed. And a mandatory minimum coming in and saying there is no situation ever where something less than 30 years should be imposed. We can't find that. The last thing I say is what we see right now with mandatory minimums is they are scattered across. As I mentioned, 30-year mandatory minimum for first degree murder, 0 for second degree murder. There are no mandatory minimums for some of the most serious human trafficking crimes. There are no mandatory minimums for some sex abuse crimes. There are mandatory minimums in other cases for a range of kind of lower level conduct, or for where there's a weapon involvement down to 5 years, even though the crime itself, something like felony assault, might only carry a 3-year term. We have historical happenstance, which is accounting for how the mandatory minimums that we have on the books now have arisen. Carjacking in the 90s, you name it. And those mandatory minimums reflect a real outrage, rightly so, by the community at horrific crimes, and a desire to respond to that strongly. Unfortunately, the evidence really shows that mandatory minimums do not deter crime, right? In fact, what they do is they don't even provide the consistency that you might think they do, because it's another tool in charging, right? And we don't control how charging works, and they can lead to inconsistent results, the very things that many mandatory minimums were set up to end. So on this one, I really point again to the many authorities out there, expert bodies that have said, eliminate mandatory minimums. And in the district in particular, where we have such an arbitrary and almost capricious scattering right now of mandatory minimums, that relying on those in the system is not justifiable.
Well, and I don't want to speak for our other panelists, but I feel like if Professor Butler was still here, wouldn't he say to me that part of the creation of mandatory minimums saying, hey, legislatively, we're trying to put a floor on something, which more often than not comes from, you can draw a direct link to an episode of carjacking is a very good example, that act in and of itself creates the structural racially unjust system and process and procedure that then becomes what is the system, becomes baked in, becomes that structural injustice. I'm putting you now, Mr. Schmeckel, on the spot of having to be Professor Butler.
I cannot fill those shoes. I think the main message, if Professor Butler here would say, is that mandatory minimums fuel mass incarceration. They are a critical aspect for why people are put behind bars when the one person who is in an objective position to weigh what's happening in the case, the judge, the trial judge at sentencing, they would disagree with it. That's the whole point of this, is to prevent that one person who is best situated from making what they think is right. Now, what we see nationally, and we can see it in the district, because of those mandatory minimums, people are getting longer sentences. They are often attached to some of the worst crimes, not, as I mentioned, not always, but they're turning, they're keeping people behind bars, and those people are Black men. Again, I can't fill Professor Butler's shoes on this, but I think I can confidently say that he would fully support the end of mandatory minimums.
I'll just add this, and Ms. Hankins, you had your hand up, so if you wanted to add something to this, but I will reflect that as an elected official, when there are instances that are egregious, that are serious, that are painful, that are harmful, that are hurtful, as an elected official, you absolutely get the pressure point of what are you going to do about it? And as the legislative branch, there are not a whole lot of tools in that toolbox because you're not the executive. And I think all too often, the legislative response is, well, let me do the thing I can do. And that is, let me show you how I care by starting to write in mandatory sentences. And so that then starts to create more and perpetuates what we've got. But I can certainly reflect on what you're talking about that. So Ms. Hankins, let me let you, maybe I misread, but if you wanted to add anything, I would welcome that. I do note Deputy Mayor Geldart noted he has to step away in just a few minutes for a previous engagement and meeting. So Deputy Mayor Geldart, thanks for being here. We know you got to step away.
Thank you, sir.
Sorry. I wanted to respond to what you just said, Chairman Allen, and that is, when there are harms in the community and people are victimized and people are killed, we do want a response and someone to be held accountable. I do think, however, it's really important to not lie to ourselves and say that's the only response that's possible. It's a response, it's a piece of the response, but I do think that that's part of what we need to have learned from how we responded to crime in the 70s and 80s and 90s. And part of that is about mandatory minimums. It's about crack powder. It's about how our city responded to crime, right? Which is lots of people and in the communities that are most affected by crime saying, here's what we need, right? We need jobs and we need better schools and we need drug treatment and and mental health supports. There's a ton that we need. And what we were handed every time was, how about prison? What do you think about prison? Right? And then we call that justice. And we sort of say, but somebody went to prison on that. right? That's it. That's justice. And it's not to say that that is not no piece of justice. Obviously, holding someone accountable for having created harm is a piece of justice. It's just not the only thing. And therefore, it's also like, shouldn't be the harshest thing possible, right? Because if it's just a piece and we're then looking at, all right, well, what got us to that point where that person is doing that, right? And what would have been different if they had other kinds of supports, job prospects, a family member home, right? And not a community that was completely devastated by all the prior criminal justice decisions that this council has made. And this is that opportunity. It's time to fix that. We lock up too many people for way too long. It's not working as a sole response. We can do better and open up then the path and the resources to put into some of those other areas so that communities are safer. Overall, communities are safer and people have, I think it was Liz Weiser who said, like, have hope and that it's real. It's not just like fake hope. It's like real.
Completely agree. Completely agree. And my point was that all too often that's the easy response that you'll see, right? And that's what gets us into where we are.
Understood.
Completely agree with you that, that's why let's create the district's first universal basic income. Let's start focusing on housing. Let's create the jobs. 100% agree with you on that. And those are the responses that get at the big picture. Because I know I live it firsthand, and I know it's the artifact of what got us to where we are, is that the pressure points come, and the easy, quick response is the thing that is all of why we're having to do a criminal code revision in the first place. So let me, if I can, I really appreciate that discussion completely. I do want to be respectful of time, though. I know we are getting close to the end here. I did want to touch base on one other piece. And again, there is, to be fair, there is so much that actually the advisory group and all the partners have agreed on. And those aren't the things you usually talk about in a hearing, because you really want to make sure you understand where are those areas of difference, where are those areas of conflict, and trying to understand that. So I hope for the public watching, they know that there actually is a great deal of collaboration that's gone into what's in front of us. To Ms. Suttenberg, I did want to ask, one of the recommendations you had in your testimony was that the RCCA's language about the second look expansion, sentencing modification expansion, should be dealt with separately, not as a part of this. And I think the term I heard you say was procedural. Why would this be procedural and other elements of the proposal wouldn't be?
Sure. So there's three things that we really said should kind of be disaggregated from this full package. The RCCA, just the substantive criminal law recommendations are really a tremendous effort with that merit plenty of their own discussion, even not talking about these other things. And we've put jury demandability, the deferred dispositions for all misdemeanors, and the second look into that category as things that should be discussed on their own merit. Our recommendation as to the second look is to delay consideration of that so that we do have more of an opportunity to evaluate how the recent significant expansion has gone and allow time for a full evaluation.
Okay. So would it be fair for me to characterize that as saying USAO would like the second look resentencing pulled out and separate because it should be from a process standpoint, or it's because you're saying you'd rather be able to have time to evaluate how the current IRA is performing, as it were?
Both. We think it's not at the heart of the substantive criminal law recommendations that the CCRC has, tackled. And so we have proposed disaggregating these few things that are not as central to that process. And then also we think that there should be a comprehensive evaluation of IRA in light of the recent significant expansion.
Okay. Ms. Weiser, from the AG's perspective, what would you think?
So this is one, Chairman Allen, where I'm going to have to say we'll get back to you. the Attorney General has, as you know, supported IRA 1.0 and IRA 2.0, and much of our analysis was based on the idea of brain development and when criminal acts are perpetrated by young people and how we should look at those instances. But I can tell you that we have not had a full enough conversation with the Attorney General about this aspect of expanding IRA. So I would just ask for a little bit of time to let you know in short order in writing, if we could, to let you know what our position is on that.
Okay. This to me feels one where I'm trying to make sure I understand. Like I can appreciate that there will be people will have different beliefs about whether or not sentencing, reconsidering sentencing after 15 years is a good idea or a bad idea. What I'm also trying to understand though is how would it be separate from a procedural standpoint? Like why would this be pulled out from a process standpoint compared to the other elements? So again, what I'm trying to say, I can respect the fact that people are going to come at the decision itself differently, perhaps than myself or others, but I'm trying to make sure I understand what procedurally or what from a process perspective would warrant one element being pulled out of the package.
Sure. So I think what I'm understanding you asking me about is whether or not I agree with the OAG agrees with USAO about pulling the IRA discussion out of the bill as a whole. Is that the question you're asking me?
Mm-hmm.
Okay. That is not something that we are contemplating in terms of our follow-up in our conversation with you. We think it's appropriate that it's within this bill, just like the jury demandability is and other elements of this that the U.S. Attorney's Office might characterize as more procedural. We think that it's appropriate that it is within this bill. It's just a matter of whether or not what the office's view is about this particular population of individuals that would be eligible for IRA with the way that statute is written in this bill now.
Okay. Mr. Schmeckel, as you were pulling this together and working, was there a distinction drawn between what some people said was procedural issues versus other substantive decision issues? Why did you feel like this is all part of one package? I mean, and I guess, wouldn't this align with the model US Penal Code as well? Which I think has been a lot of your source material too.
Absolutely. So, this is a core recommendation of the new sentencing model penal code, along with, so many of the things we've talked about, right? And again, so it isn't just us. This is this mainstream expert body. Many district judges, federal judges sit on the ALI's council, not even like ordinary members who vote on this, but also their final counsel. That body has said, throughout all these issues, no mandatory minimums, a number of other issues we'll get to on judicial deferral mechanism, the definition for sex assault, all these things, including this broad-based judicial review mechanism for individuals, regardless of their age at the time of the offense. That is a core piece of the sentencing recommendations. And the reason it is inextricably linked is not because it is more procedural in the sense that it follows after the decision about liability, but it is central to any discussion of sentencing. We have to have a discussion about long-term sentences and how those play in. From the ALI's commentary, one of the things they really emphasize is that this recommendation of theirs, which we have also put forward, is coming from a place of humility, right? Fundamentally, judges err. And we don't know how an individual is going to be, who they are going to be in 15 years. What the surrounding norms are going to be. If you look at the changes over the last 20, 30 years in terms of drug offenses, massive change, right? We have people currently serving extremely long sentences still, some of whom may be eligible for this, for crimes that had, again, very large mandatory minimums, drug crimes, other things which the public norms have shifted. It isn't to say in any of these instances that that person deserves to get out. let's just be clear, right? Like that's not what the judicial review mechanism is about. It's that after 15 years of these long-term sentences, there should be a judicial review to see if all things considered, and there's a whole list of factors, as you well know, right? To consider the interests of justice, and that this person will not be a public safety risk. If those are found, we need to give that person consider resentenced, right? And that is just a blunt reality of the fact that the district doesn't have anything else. There is no other mechanism to see if somebody is eligible for release.
Right.
If the district had parole, as so many other jurisdictions do, we would be in a different place. The need for this mechanism would be totally different. But as it stands, no, we have some of the toughest kind of truth in sentencing type crimes that were set up, with the 2000 change by federal law, right? We changed into this new truth in sentencing system. We got rid of parole, and there's just no mechanism to see, does public safety, right? Does public safety still require this long term? And they're also, bringing in, is there anything else, right? Are the overall other interests of justice in the sentence served? All of those things come to bear. And that is the reason why I think that the ALI continued to propose very lengthy sentences, right? Again, an effective life with the possibility of release, and also having this mechanism in place. That combination creates both the possibility of a very long sentences, right? They wanted to maintain those. And again, public defender service, many have spoken out against those very long sentences, but a critical piece of that, I think, from the ALI's perspective, was that they have this other mechanism in place. So they go together.
Because it doesn't create a mandatory maximum. What we're talking about is a judicial review, an independent judicial review. To what degree, was there any conversation around, as I look at the totality of the district here, so we have IRA, which is going to be the opportunity to go back before a judge and have the judicial review for those that were under age 25. We have a compassionate release system in place for those that are 60 and older, so our older incarcerated residents. And then there's the gap in between. And I think I heard it would be around 330 people or so that might be eligible today. And I'm assuming that might change numbers based on time served, things like that, but ballpark, if that's what I heard. Was there discussion around that really is kind of looking at that middle tier? If the DC law is already in place on compassionate release for the 60 plus, and then for people who are at this point, could be 40 or 50 years old, but for the offense was when they were below 25.
Well, I would just chime in and say, no, not much discussion, I think, amongst this group, because the question of what's going to happen with parole in the district is itself such an active item. And again, related to this, right? Like, I think the conversation would be different if the district had a parole system or had a path to a parole system that provided some sort of review mechanism for exactly what you're saying, this in-between folks who are under 60, not compassionate release, and were over, 25 or older when they committed the offense. What happens for those folks? Right now, there's nothing. There's some active conversations, I think, that have been floating around now, right, for years around this. The ALI's proposal, just to be clear, was instead of going down the parole path, to provide this mechanism instead. Okay, so they're very different. It's part of that model. Now, again, I think we would not have submitted this proposal if there was a parole system that gave a similar chance for review of these lengthy sentences. But that isn't on the horizon. As far as I know, it's definitely being talked about, and I think there's a lot of concern. But this is way to move forward with that and provide a solution that is judicially guided.
Okay. I guess what I'm kind of trying to get at is there a or was there discussed a public policy rationale, a legal rationale that we would have a judicial review for a group of population over here, judicial review for a group of population over here, but then nothing in the middle. So that we, I've heard the phrase, you have bookends, but no books. Does that make sense that we would want to have consistency across that? And is that part of what this is intending? And I guess I'll ask one other question and then I'd turn it over to the panel too. I'd love to hear your thoughts. Is, as you were considering this proposal, is it like, what's the substantive difference between a penalty of 20 years and a penalty of 20 years with the possibility of seeking a judicial review for a sentencing modification after 15 years? Like what becomes the substantive difference between those two sentences? Mr. Brandon?
I mean, from a research perspective, almost everybody underestimates the extent to which criminal conduct and any kind of criminal involvement changes with age. It is a rapid drop off, and we just there's new research coming out of Chicago and Harvard showing that everybody, like not, I won't single out prosecutors, although a lot of the research was done with prosecutors, underestimate the drop in the likelihood of any kind of criminal activity as people get older. It's a very steep drop off. And so I think, if you want to think about it just from a public safety perspective, if you want to think about it from and there's no evidence at all that these really lengthy sentences have any kind of deterrent effect. There's more and more evidence coming out that they have some kind of criminogenic effects. And I'd be happy to include citations to all that recent research in my when I submit my testimony.
Thanks. Ms. Hankins, I couldn't tell if you were raising your hand earlier.
Yeah, I've been up and down, up and down. I do think, right, to answer your first question, yes, there should be books, not just bookends, right? That there doesn't make sense to have the I won't say it doesn't make any sense, right? But to have the ability for review if the offense was committed when the person was under 25, and the ability to look at who the person is and their whether they pose any risk to society in the interest of justice when they're over 60 or 65. I'm not sure when compassionate release kicks in, but nothing in between, as if aging from 25 to 50 somehow isn't like a totally different person. Boy, am I not who I was 15 years ago, 20 years ago. And it's individualized. I do think, like, to the sort of point of thinking about brain development and stuff, that was certainly sort of the genesis in the district of thinking about this issue. And to me, that just means that may be, and particularly when you look at what the factors are, none of these cases are easy, but easier than the 30-year-old, right? That it might be easier to see the 16-year-old, the 17-year-old, the 18-year-old versus the person who commits a serious crime when they're 30. But that doesn't mean that someone who committed a crime when they were 30 and now they're, math, 45. Thank you, Don says that's great. That doesn't mean that we can't take a look and see who they are at 45. And they might not get out, right? This isn't a mandatory release, I think, as you said, Chairman Allen, right? But this is a look, and it's not a go back and look and go back and look and go back and look. It's 3 chances spaced apart, and then that's it, it's over. It's not a constantly getting to go back and say, look who I am now, I've changed again. So the possibility that we're going to take a look and say, were we right 15 years ago? And that's also not even that the person automatically gets in at 15 years. They're eligible. That doesn't mean they're actually going to file then. It, you know, certainly if they're waiting around for a lawyer with the backlog that there is, like nobody's filing, say, at 15 years, although they're eligible, and it'd be nice to get to that point. But even if it's then, right, it's taking a look. And then the judge has discretion, and the victim has an opportunity to come in and talk about the offense, and the prosecution's on the other side, right? It's not one-sided, and there's nothing mandatory about it. It's a good idea. We should do it.
And I guess I would think that the argument would also be, right, the practical impact of not doing this would mean that, in other words, the practical impact of maintaining the status quo would be that it just depends on your age. And we would end up with a bracket of individuals who no longer pose a risk to public safety. Justice would warrant relief, proven rehabilitation, but they have to be held until they are over the age of 60, which, again, we're talking about a population that is 90% Black men. Life expectancy is in the 60s. So you're talking about that compassionate release at age 60 means if they're successful at that point, there's a handful of years left. That's what the status quo means, of maintaining that. Okay.
It also means that there will be people who would not be in prison if they were sentenced under today's statutes who are in prison, right? And will not have a chance to have that look given the revisions that we're now making and have been making over the past few years to our criminal code.
And I guess let me chime in too and note, again, this is about real changes happen in time, both in the person who was convicted, but also in society, right? Don's saying the laws change, and the judges change too. The sentencing changes. You know, there have been very few cases. You know, by our research, about 10 cases that received a life sentence in the last decade, and there are many more that have dozens of years, effective life sentences, far more than that. But for actual life sentences, there's been a real shift this last decade for some egregious cases where usually they have many convictions as part of that case, right? Many bad things, that multiple life sentences in the same case, but 10 cases, 10 people. And you compare that to the prior decade in the 2000s and the 90s, totally different statistics. And the reason isn't so much that it's in the sentences that are coming out, right? A lot of these, you know, again, I think the BOP number that Alana Missentenberg provided, you know, 335 individuals now who would be potentially, you know, affected by this change. The vast majority of those are for crimes back in the 90s and the 2000s when sentencing was fundamentally different. So, you know, how do we look at that today, right? How do victims view that today? Victims are also may have changed over time, maybe not, right? They are a part of this process and certainly contemplated in the second look review as well. So, you know, opportunities to review after this time, a holistic review to see, does this still make sense, is a way of just putting a question on what otherwise is a machine and a system that is set up to do its best, but it's doing that at a point in time right after conviction and just can't see where things are going to go and what's going to make sense down the road. Yeah.
I think that's an important point as well, though, kind of your historical piece that you talked about, that you could end up with two individuals that, you know, committed the exact same offense in the exact same circumstances. They could be serving in the exact same cell. They'd be different ages. And so simply because of what their age is, they received different sentencing and they would have different opportunities, even though it was the exact same offense, exact same conviction. And so standardizing that's the way that I'm reading what you've put before us, is an approach to try to standardize that across the board, which both I think helps address your historical challenge that if I'm sentenced in 1995, 2005, or 2015, the exact same thing, I'm probably going to end up with 3 very different sentences. And you're standardizing the opportunity again for just having a uniform system of what that looks like for a judicial review. So, okay. Well, I appreciate that. All right, I think we are coming up at 3 o'clock and we have used all of your time very well. And I'm really grateful for everybody's testimony. I don't know if there's anything anybody wanted to add real fast before we wrap up. But again, I definitely want to thank the entire panel, but also all the staff behind you that have been working so hard to help us think this through, to make recommendations, and a healthy tension of pushing and pulling to try to find our way to do this. And I'm really grateful for just the really candid, honest engagement that everybody's had throughout. Maybe Mr. Schmeckel, since you've been helping lead us all the way through this, I'll let you, if there's anything else you wanted to add before we wrap up.
Absolutely. First, I want to thank all the people here. You asked at the beginning what the process is, and I think you had some glimpses of it today, right? Which is to say, diverse views and hypotheticals being tossed out, a little bit of chaos, a lot of smart people, a lot of dedicated people. And I really want to say that we talk about having kind of reasonable differences on a lot of these issues. And it's because I think, people, partly there are institutional interests, right? The institutions represented here today have, certain lines that they consistently try to put forward. We have tried to navigate that as the CCRC, as an independent agency. It hasn't always been easy. And we really want to respect the fact that this is how you do well. The adversary system has some pluses and minuses, but when they're, these folks are at the table, and I have no doubt that, again, as all these offices have said, they've had multiple people looking at this hard, coming up with counter arguments, pushing on weak spots. It has helped us create a piece that I think it's well researched. We've got this big commentary that really details out changes in law. We have this a record of how the different concerns were handled. And I want to really point out, there was a number of things we didn't get to today. Some questions about particular penalties for particular offenses. I would just say I could go on for a long time about them, but we've fleshed this out. These have been aired before, and they're complicated is the other thing I'd say, right? These, where we're talking about a criminal code, we're talking about a set of laws that is set up to reach an overall a just result, but it does so through, some really complicated ways, right? And ways that are counterintuitive. It doesn't make sense for somebody coming in to think, I did this one thing, but you're saying 3 different charges apply and all these different considerations. It is hard. And these are expert players. We have done our best to present a package that takes all those complicated legal considerations and tries to make sure that in the end, it generates a result that is fair and proportionate. So, as the committee considers, as the council considers, I hope, we as an agency are standing by to help navigate and say, okay, in this situation, how would this work out? We'll be there to help figure that out. What crimes are available? What are the procedures? What are the penalties from all the different crimes that would apply to the situation? Those are really important to think about, and it's tricky stuff. So we will do our best, going forward as you try to, I think, consider this bill, hopefully move it, this fall and towards implementation. We want to be available to make sure that these nuances are you get our voice along with the many other voices you're going to hear from different directions, pushing in different ways. And I think out of it all comes some really a big step forward. And I think the fact that there is this degree of consensus on something so big is actually really monumental. So thank you, and thanks to all the advisory group.
Thank you, Mr. Schmeckel. That's why I kind of commented on earlier as well, because I didn't want people to obviously a hearing explores and probes where there's not necessarily agreement. The package is put before us again as the product that actually represents a whole lot of agreement and a whole lot of back and forth and give and take from all the partners and from everyone in front of that. So I certainly hope that's not lost as we do, of course, try to probe and understand where those differences are. Mr. Schmeckel, this is the last of our 3 public hearings. And so I would definitely want to make sure I gave you that chance to speak and kind of give us our last word, because we wouldn't be here but for the hard work that you've done. I know you've had a great team and a great staff that's done that, but you've really helped lead this entire process, brought people to the table, created that healthy tension in a space where people can work back and forth, and ultimately have put forward an incredibly thoughtful product in front of us for us to consider. And so I appreciate it. I know it is the culmination of a lot of work that went into it. So really appreciate that. And I didn't want to let this opportunity pass with our final hearing to make sure I say that to you directly. So we appreciate it. Thank you. My thanks to everybody. You're all special too. But just wanted to give Mr. Schmeckel some direct love there. But I appreciate everybody's testimony today again. Really, this was one of the more substantive hearings I think I've been a part of in quite some time. So I really appreciate it. This is going to conclude the committee's 3rd hearing on Bill 24-416, the Revised Criminal Code Act of 2021. If there are any members of the public that were unable to provide live testimony at our hearings on November 4th or on December 2nd, but want to share written testimony on the bill, please email it to us at judiciary@dccouncil.us. The record is going to close at the end of close of business on December 24th. The next hearing of the committee will be on January 6th, 2022. On that day, we'll be considering Bill 24-507, the Elections Modernization Amendment Act of 2021, and Bill 24-489, the Expanding Fee Waivers for Low-Income Litigants Act of 2021. Witnesses can register to testify until January 3rd by emailing us at judiciary@dccouncil.us. With that, this concludes the Committee on the Judiciary and Public Safety's public hearing on Bill 24-416, the Revised Criminal Code Act of 2021. Thank you all very much, and the hearing is now adjourned.